Hello everyone. Hello everyone and good evening all. And today in this session we're going to study agency rule. And once again I warmly welcome all. So and this is a testing part in your question in your exam paper. So let's study this today. Right. So what is agency? So agency is a fiduciary relationship between two parties where one party authorizes another party to act on behalf of him and the other party act to do so. So like it's a nice theory. Agency theory. No. Agency means something like this. Now let's say there are two people and one is the head and other is the agent. Now one person is telling to do like certain activities to another party on behalf of him. Like he's not doing, he's appointing another person to do. Like we can take an example, something like this. Um, a teacher and a student. Now, some teachers are telling, like go and do this work, do that work. Their work they are giving the students to do. So where the teacher we call is the principal and the student is the agent, which means the teacher's work is done by another person. That's we called as agency. So there are two parties here. One is the principal, the next one is the agent. Principal means the person who is giving the authority, okay, who is telling to do so. Agent means the person who is receiving the authority, who is to whom we are giving to do that activity. Okay. Now, creation of agency. Okay, how this relationship, how agency is created. So there are different ways how this is created. Okay, let's see. The first one is agent must have a capacity to contract. Agent should possess a knowledge on his role. He or she shouldn't be a minor and a bankrupt. Okay. Now we can't like appoint everyone as an agent. No. He must have like some like capabilities. Now if you're gonna appoint an agent, you should take certain things only. You have to appoint him. So the first of all, he should have a capacity to the contract. No, he should have a knowledge about what type of activity you're going to he give him. He should know about that, and he should know about what is his role over there. And he should not be a minor, and he should not be a bank. He should not be bankrupt. So that's the first one. Second one is like agencies created in five ways. The first way is by expression. Second one is by implied agreement. Third one by ratification. Fourth one by necessity. And the fifth by estoppel. Okay. Let's see how an agency is created by expression. Okay. An auditor, auditor, an agent. An agent is appointed either verbally or in writing. So an agent, you can appoint an agent verbal, or you can go and tell, okay, you go and do this, something like that. That is verbal, how we appoint an agent. Or in right now, in form of a document, like by within certain procedures, like you tell, okay, you are an agent for me, something like that. Then verbal appointment. So this agent cannot subscribe to a deed on behalf of the principal. Okay. Now, if we are appointing an agent verbally, which means like through word of mouth, we are telling him, okay, you are an agent. Such type of an agent, he can't go and subscribe to a deed. I mean, he can't go and like agree for a deed. I mean, he can like sign a deed on behalf of the principal. Like because like he's just verbally appointed and there is no need legally proof that okay he's an agent. Therefore, like he can't go and what sign a document or like on behalf of the agent, he can't do those things. Such as an agent. The next one is by written appointment. Okay. So this written appointment can happen in two ways. One is by a way of document not being a deed. Next one is by a way of a deed. So by way of a document mean okay it's a document but not a deed. It's a document but not a deed. The next one is by a way of a deed. Okay, it's a deed. Okay, let's see what's that. So let's see what's a deed first of all. It is a document drawn and attested by the notary of public. Okay. So which means a deed means a document, something a document that is authorized, attested by the notary of public. A lawyer has authorized it. Okay, so like a legal document. Simply we can tell like that. Now, what is power of attorney? So it is the power granted to the agent by the principal by a way of a deed. So that means, uh, I'm like telling you like written appointment is there. So there one is by a document, but it's not a deed, which means it's just a piece of paper where but it is not authorized by the lawyer. The next one is uh, like next one is by way of a deed. Okay, that means that is authorized. So if a agent, if a principal is giving a power to an agent through a deed, that power received to him we call what? Power of attorney. That's the main two differences over there. Okay. Next one, an agent appointed through document can enter into contract only verbally, but not by the way of a deed. Now, an agent, okay, an agent uh, who is like entering into a contract. Okay, let's say now we'll be like understand further like when we're going behind uh, an agent also like on behalf of the principal, an agent is going and signing a contract. Let's say something like that. So when an agent who is like appointed through a document, which means just a written paper where it's not authorized, then that person can enter into a contract verbally, not by a way of a deed. That means he can't like he can like go a contract with another person on behalf of his principal in a form of a deed because he is not a person who is appointed by the law. I mean, law haven't like authorized it. In front of the law, he is not accepted as a like agent, but as a document, yes, something like that. Hope it is clear. Okay, now there are two case laws related to this topic. One is Haley Hutchinson versus Brayhead Limited and Medica versus Spain. Now I'll explain that case. Now, Richard had been the managing director of Greyhead Private Limited. Okay. Now, there is a company called what? Greyhead. It's a company. And in this company, Richard, he was the managing director. He's the MD. Simply the managing director. Yes. Brayhead Limited had shares in Purdue Electronics Limited. Okay. Now this Brayhead, they have purchased some shares of who? Purdue Electronics, so which is another company. When Purdue Electronics Limited taking actions to obtain an advance from Haley Hutchinson, in order to facilitate the advance requirement, Richard, as the managing director of Brayhead, offered an indemnity against which Haley Hutchinson granted a credit facility worth of 45,000. Okay, now they have bought shares now here. Now this Purdue Electronics, they want to get a loan from who? From Haley Hutchinson. They want to get loan. Right. Yes. In order to get a loan, okay, yes, we should give indemnity, right? I mean, like something like let's say if this company didn't pay me, like someone are like they're like I mean to like what's that, like collector, no? Something like that, like protection, something like that. If body electronic didn't pay their money, okay, the Richard is saying, okay, I'll pay it. No, he's like he's giving a collector, no, something like that. No, he'll tell, okay, I'll take the responsibility over there. Now when Haley Hutchinson, okay, he was giving the loan at that time. What is Richard is doing is for this person, he's like, okay, I'll take the indemnity. I'll give you the indemnity if Purdue didn't pay. Then he's giving that uh, oath to Haley Hutchinson on behalf of who? Purdue, right? Okay, now he's saying, okay, then they're going to take a loan worth of how much? It's much of a amount, $45,000. Following the loan, Purdue Limited was wound up, and Haley Hutchinson demanded to get the indemnified under the agreement for indemnity. Now what's happening? Now this Purdue, he is what? Winding up in his business. Business is what? Shuddered. Shudder. Okay. Now what is Haley Hutchinson? Okay. Now you give me the loan. You told no. But give me now, you give me the loan because this person is not there now. The court held that although Richard had not expressly been authorized to provide an indemnity, as regard the position he had held in the company, he has the implied authority to enter into such an agreement. Accordingly, the owners of Brayhead Limited were held to be liable with regard. Now, like third is another company, and just this Brayhead, they have bought some shares from this third electronic. But now, as like just we are telling you, okay, now you tell, okay, Purdue, no, Haley Hutchinson, he is going to an agreement, Purdue, no. And even for Purdue, like Richard is just a managing director of Brayhead, not Purdue's one. And like how he can once again do that, he can indemnify them. Like, are there any logic over there? But here, what is happening is the court is telling that, like, since this person, the Richard, now what is his position? MD. Now he's getting an implied authority. Based on his authority, he's receiving a power. So then he's going to an agreement, like because of his power, no. As his power, he's telling there. And even they have taken just shares only, but because of this power, because of this position, he receives an implied authority. Therefore, the owners of Greyheads are liable to indemnify Haley Hutchinson. So, because of whom? Because of this Richard. Now, what is happening is, because of the implied authority, this person is becoming an agent to this Podio, who is the principal there. So, therefore, now his agent, no, his principals are who? Shareholders, no? Then even the other one is liable to do so. Now, when he is going to an agreement, yes, he was the principal, sorry, he was the agent and he was the principal. So now, since he is not there now real principal of Richard is who? Brad, no, they are the owners. Then because of the agent activity, the principal is liable to pay the amount. That's about this. Hope it is clear. Now, next one. That tier versus Sandvik. Okay, now A had employed B as the manager of Victoria Hotel. Okay, now there's a hotel called Victoria. So in this hotel, A, as a person called A, he has employed B as the manager. As the manager. Right. Okay. Victoria Hotel with express instruction not to purchase cigarettes on credit. Okay. A is appointed B as manager and is stating, okay, B, Mr. B, you don't purchase cigarettes on credit. Despite this prohibition, B purchased cigarettes on credit from C. No, A has told him, but C didn't like ask that. And what he do? He listened to A, and he has purchased cigarettes from C on credit. When C demanded the payment of the sale price, he argued that B had acted outside his authority. Hence, he was not bound by the contractual obligation. Now, what is happening is now, like he's a what? Principal. Let's say his own owner here. Right. This person is buying on behalf of A. No, the C is asking money from A. First money. Now, what does A study? No, he said, no, I can't give you the amount. I have told this B not to purchase cigarette rate. Now, he has gone beyond his authority. Now, liable for that. The court held that since he had not been aware of the limitation of B's authority in advance, an agency by implication arises between A and B. Accordingly, A as a principal is liable to pay the money. What the court is telling. Now, C, okay, the cigarette seller, so like he doesn't know about B, no? No. He has told B, no. Like A haven't told C, okay, don't give cigarette and we won't purchase cigarettes on credit. C, he doesn't know what's B's authority. So therefore, court is telling, okay, since C is unaware of B's authority, there what an implication or agency by implication is created between whom? A and C. This means A have to pay the due amount to C. That's about this one. I hope all these parts are clear. If you have any doubts, you guys can ask. Right. By implied agreement. Okay, the second method how an agency is created is to what? Implied agreement. Okay, let's see about that. Now, the first implied agreement, like how can we form this? Implied agency between husband and wife. Okay. Now, what's about that? Now, there's an implied relationship between the husband and the wife. So that uh, relation, I mean that agency is creating because of the marriage. Okay. Now let's say like when the wife is entering into a contract with a third party, husband becomes a principal and wife becomes the agent by implication. So now let's take an example. Uh, this is a shop, a grocery shop. Okay. Now wife is there here. The wife is taking goods on credit in this shop. Let's say like per day, like for 5,000, she's taking some item. No, let's say if for 30 months, how much? 150,000. No? Now, this retailer, even he's giving the goods on credit to this girl, this women, and okay, he's telling, okay, I'll ask your husband to what? Pay the amount. Now, let's say he goes to the husband, the retailer, and if he's asking your five, is like per day she's purchasing item for 5,000, and for this month your bill is this much. If she's asking like that, now the husband he can't refuse that. He can't tell like I didn't buy no. My wife no bought. So you go and ask her. You can't tell, he can't tell like that. Because they are for the by wife, the husband is the principal and wife is the agent. So whatever the activity the wife is doing, the husband is liable for that. So therefore, he have to what? Pay that 150,000 without telling anything to whom? For that retailer. So that's the relationship got created there. Okay. It's a nice move. Women receive the power. The next one, implied agency among partners of a partnership. Okay. Now you might have learned under your business studies that partnership, even under the first stage business environment, even there you might have learned about partnership. No? So the characteristic of a partnership is what? Mutual agency. No? So according to that, what they're telling. So like all the partners they are liable to what? Each and every other partner's activity. So one party is acting as the agent of other parties. No, that's how we tell. So if one person is doing something within the partnership for his activity, not only him, all the other partners are liable for his activity. So why no? What's there? That is once again implied relationship. So for one partner's activity, other partners are also liable. Then that liability is creating because of his implied agreement. They are the agent. So this relationship arises due to mutual agency. All the partners are liable to the activities of each and every partners. Hope that is clear. Right. The next one is what? By ratification. Okay. So how an agency is created to what? Ratification. Let's see. So when agent is entering into a contract, due to his power, principal is not bound to it. But if certain condition existed in the contract, principal can ratify it. So ratification. So what is ratification? So ratification means like this. Now an agent, okay, an agent. Let's say, let's take an example, something like this. A. Let's give him a position. Is the head of let's say cutting department. As person called B. Let's take like this. Person called B. Uh, BC. Right? So that's a person called A and another person called B. Then let's say B. He's the head of sales department. And let's say he's a CEO. So who is the head of even B? No? Then so what's happening is he's a head. Okay, let's say B. Okay, now he is going to a contract with now he's going to do sales. No, the main source of income for business is sales. So he has a big role. The main person who's like going to like income the income. No, he's going to collect income. The business. It's very responsible. No? Then he's guided by let's say the CEO. That he is giving all the like top level managers now there. So what's happening is uh, this person B he's going to a contract. So he has a big power. Whatever contract he wants, okay, he can go no because he has the power. But certain time, like let's say any clashes happening so because of this work, some issues are happening, or like some contracts are we are losing, or some legal issues are coming. There are different actions can happen. No? But he is the principal, sorry, agent. His principal is CEO. In certain situation, okay, the principal like, he can tell, okay, I'll rectify it. Okay, I'll take my side. I'll correct it. So I'll manage it. I think the A can tell. Okay, so he can tell something like that. Then that is because of what he's like his power. Not even the principal has the power. But in order to do so, in order to accept that, okay, fine, I'll take the responsibility, there should be certain conditions. No, agent, when he is going to contract with another person, that should be in a way the principal can ratify it. So, what are those ways? What are those conditions? How can we ratify it? No, as we think we can't. A principal can okay, tell whatever the agent do, he can't take the responsibility. But in certain situation, automatically or legally, he is bounded to that. Let's see what are those conditions. So there are nice case laws over here. If agent has entered by his personal need, then principal can't rectify it. Okay. Now, if the agent, if he's going to a contract by his personal need, let's say Let's keep two names. The principal name is Mr. A, and the agent's name is Mr. M. Now, if the agent, Mr. M, if he's going to a contract, I mean, if in the contract, if he's signing as M, or like he's telling Mr. M, then the contract is in whose name? Mr. M's, no? Then the agent, then the principal, he can't rectify it. He can't tell, no, you have won the contract in your name, not in my name. So, not liable then. I can't rectify that. So, like that, what principal can tell for that. Okay. Let's see, there's a nice case over there. Haley Nexted versus Darren. I'll explain that case. Okay. The principal had nominated an agent to purchase grains at a specific price. Okay. Now the principal is there, and like take P for principal, and the agent is there. Principal is telling the agent to purchase some grains. These are some grains. Some grains, but on a specific price. A specific price. The agent purchased grains and entered into a contract in his personal name at a price above the prescribed price. Okay, now what is agent? Okay, he's, let's say he's buying from a person from C. He's buying from C in whose name? In his name. In, let's say his name is Vimal. So he's like in the contract he's going in whose name? As Vimal. He's going as Vimal. And what this person is doing, let's say the agent, no, he had told, the principal has told the agent to purchase at a specific price. No, let's assume the price as 1000 per kg. So what does this person Vimal has did is he has purchased 1200 per kg. Now what happened? Without revealing his character as an agent, no. And also so the Vimal, he has purchased the from C, who is our seller, and he has purchased it in his name, and even he haven't also revealed that he is an agent. I mean, he is an agent of his person. As to his wish, he has purchased, and even that, and also like he has purchased above whom, above the like, prescribed price. Even if the transaction was ratified the principal, the court was of the view that since the agent had not disclosed that he was acting on someone's behalf, the principal was preluded from ratifying the transaction. Okay. Even though the principal, okay, fine, no problem, Iman, I'll manage it. Even if the principal tells in that way, what does a court tell? A court is saying, no, you can't. You can't rectify it because he has gone to an agreement in his name, and also even he haven't like told to see that, okay, fine, I'm an agent, you are my principal, like that you he haven't disclosed. So how can you ratify the transaction? You can't. The law is preventing the principal to ratify for what? That transaction. That's about this one. So then that's the best example for what? For that for that is for this first point. The second point is principal must have contractual capacity when the agent entering into the contract. What's that? Now, when the agent, okay, when he is entering into the contract, the principal, he must have a contractual capacity. That means he will be bankrupted. Like he should be fine. He should be okay with economically. He should be fine. Uh, when the agent is entering into what a contract. Okay, Hanley versus Baxter. That is the um, let's not do that. A prompter who had been tasked with registering a hotel company bought on credit a bulk of whiskey at a considerably lower price. Okay, now what's that? Now a prompter, sorry, a promoter. Okay, a promoter, there's a promoter look. So what this promoter has done is, has done is a promoter who had been tasked with registering a hotel bought on a credit a bulk of whiskey at a considerably lower price on behalf of the hotel company. The hotel company later used this whiskey. That means the company rectified it later. Subsequently, the hotel went bankrupt. In an action instituted by the seller against the promoter to recover the sale price, the court pronounced that the ratification was no legal effect inasmuch as the company did not have the contract capacity to contract at the time the promoter entered into the contract for purchase of goods. Okay, now what's telling there? That's a promoter. That's a promoter. So this promoter, what he's doing is, okay, that like there's a company called this hotel company. So what is happened is for this hotel company, okay, the promoter okay, the promoter so he has a registered hotel company. Okay, now what he has did is that he has bought some whiskey on credit at a considerably lower price on behalf of whom? This hotel company. The hotel company later used this whiskey. Okay, now this promoter he has given certain like whiskey to this company. What does this company has done? Okay, later they have used that. They have consumed. They have sold it. Okay. Subsequently, the company went bankrupt. Okay, no, this person has given a low price, but they haven't made the payment, and even they have used this. But later, what is happening is the company went bankrupt. In action instituted by seller against the promoter to recover the sale price. Now, what happened is the seller. So he what does he has did is what for this promoter they have filed a case what to recover their sales price. The court is telling that a ratification was of no legal effect in a much as the hotel company did not have the capacity to the contract at the time the promoter entered into the contract for purchase of goods. And he's a promoter now. Now he has bought whiskey from another person, from a seller. Now this seller only has given the whiskey to this promoter. This promoter has sold to who? For this hotel company. So when hotel companies want to enter, like the hotel company is not having what? The contractual capacity. But they are purchasing it mean their personal credit, even they're using that. But as they went bankrupted, they are unable to what? Pay the amount to this promoter. No. So which means they can't pay the amount to the seller as well. No. Then what the seller has did is he has filed a case against this promoter. Anyhow, you want the money. You do it like the court, you ask the money. The court is telling that, okay, since this company does not have a contractual capacity when they're entering into the agreement, what has happened? The what has happened is the court is still okay. Uh, but the company is what? Sorry, this promoter is what? Not liable. Means, yeah. Sorry, he can't. I mean, like that ratification is not like the company is ratifying. No, this company is ratifying it. So now the but the court is telling that no, this ratification is not valid. Since what? They don't have this company is not having a contractual capacity, which means what's happening there? An agency cannot be created. No? That's about this. Okay. Now the third point. Uh, Either should disclose all the material fact to the principal. Now, what does the either should do is okay when he is entering into a contract with someone, the either should tell all the material facts, all the what important, all the material thing the principal. Or he should like tell the principal, okay, this is our contract. I'm gonna sign this contract. Shall I? Or like we will get these type of benefits. So these are the parties. All those things we have to what? Info. That's about this. And the fourth point is principal should ratify the entire contract. Ratification of part of the contract is not valid. Or let's say uh, A. Okay, once again, let's take the same person. Same. Let's take another person. Or let's take Mr. X. And he's going to, no, he's what? He's the principal. Mr. Y. He's our agent. Now let's say our agent is going to a contract for around 100,000. Now, when our principal is ratifying the our agent work, I mean agent's activity. So the contract is 100,000. He can't tell, okay, no, I'll be liable to pay only 50,000. No. Other 50,000 you pay. Like that, he can't ratify the entire contract, the entire thing he had to ratify, not partial. Everything he had to ratify. That's not the condition. And ratification is applied only to valid and legally enforceable contract. Now you can ratify only legally and to be valid such type of what activity. Let's say our agent is going to a contract with a let's say murderer, do some murder. Okay, you murder, I'll give you this much of a murder. Now, he's agent, but like, let's say principal is unaware of that, and like he can't go. Then after he can tell, okay, I'm the agent. I'm not the principal. He's the principal. No, I'm not liable to that. He can't tell those things. So, such type of things, the principal can't rectify. Even the law is not what letting the principal to rectify those things. Okay, let's see some case laws related to that. Brook versus Hook and Walton Partners versus Lambert. In this case, the agent had forge the signature of the principal in making the contract. Since forgery is criminal act which render the contract void ab initio, the court held that such a contract could not be ratified. Okay, now what's happening there? Now what's this word? You guys know the meaning of this word? So this means from the beginning. What's the meaning of this word? From the beginning. Okay. Now what's there is now let's say an agent, okay? There's an agent. This agent, he is going to contract the person. Say Meena. He's going to contract with Meena. When he's making the contract, what the prince agent is doing, he's placing the sign of his principal. I mean, he is placing, not the principal. Like he's what Foog. He's fogging the principal signature. So since Foog is what? It's a criminal act, no? So how can that person sign the sign of the age, his principal? So he had to sign his sign. No? Then what's happening? And then can you ratify his contract? No, you can't ratify it. The court is telling that this contract cannot be ratified because this contract, from the beginning itself, the contract is not valid. Void about you. From the beginning, there is no, it is cannot be a contract. The court is telling that. So there's such type of a contract you can't ratify because it's not legally what? It's legally not accepted. Next. Bolton Partners versus Lambert. Okay. Here, L made an offer to the agent of Bolton Partners named S. Okay, now there is a person called L is made an offer to whom? There's a person called L. L is made an offer to agent of who? Bolton Partners. So there's a person called S. So is S is what? Bolton Partners agent. Right. So with a view to let a certain property. Okay, to not give certain property. He's going to make effort to let a property. The agent is accepted the offer, though he had not been granted the authority to accept such offer. No. But no, A is offering to L is offering to S. No. Then what does this S is doing is no, he is accepting it. Okay, I'll accept the offer. But actually, he can't do so. He is not having such a capacity. No, he's not given such an authority to what? Accept. No, he's offering. This person is what? Accepting. Uh, However, Later, Bolton partners ratified the act of the agent, but not before L withdrew the offer. Okay, now the Bolton partners are they ratified the one. Okay, now this person's Bolton farming the principal is there now is ratified. Okay, we'll accept what this person has did. No problem. Let's continue the contract, but not before L withdrew the offer. But before the principals are gonna ratify this L is withdrawing the offer. No, sorry, no, I can't give you this. The court held that the ratification operated retrospectively. Hence, there was a valid contract between Bolton Partners and L from the inspection, by virtue of which L was obliged to let his property to Bolton Partners. What is telling? What does the court is telling? Okay, now you withdraw it, no, but the principal is also what gonna principal is like going to ratify when he was gonna ratify. L is no, I can't. So like that he can't do no. When I want to okay, I'll do this, total load. And that can't no. So therefore the court is telling even from the beginning, okay, from the beginning there's a valid contract between you both. The contract is valid. Only the thing is that he don't have the capacity. But the contract is valid. It's not lawful, nothing wrong. It's legally fine. Like the thing is just okay, fine. He is not aware, but he accepted it. Even the principals also tell okay, fine, we'll agree. But you are withdrawing it, that's wrong. You can't do like that. Therefore, L is what? Obliged or is liable according to court order. He have to give the land to whom? Bolton. Yes, that's about this. Hope even this is also clear. If you guys want it, I'm telling. If you have any doubt, you guys can I can clear it. By necessity, the next term. Right. So this is created when an agent the one has asked whether we'll be doing the past papers. If you have any doubts regarding how to tackle with the past papers, you can upload them to the group. It will be helping. And today we are not able to do so. If you have any doubt, you can uh, upload it to the group. I'll be explaining that. Okay. By necessity. Okay. Now, how the partnership? Sorry. The how agency is created by necessity. Okay. Let's see that. It is created when an agent enters into a contract on behalf of the principal in emergency situation. Okay. Where he cannot seek principal's guidance. Okay, what's that? No. Uh, this type of agency is created. Now let's say the principal is sorry, the agent. He is going to a contract in an emergency situation, which means he is right at the moment in an emergency situation where he can't contact the principal and ask him what to do. No, in order to tackle that situation, tackle the difficult situation, he is doing this way. Like in an emergency, like, he can't do anything. The option is you have to what? Do something. Let's say something like this. Now, there's one contract. A contract is coming. Okay, let's say if we do the construction, let's say construction business. If we do that construction, we can earn, let's say, 1 crore. The agent is not having the right to accept such type of a contract. So now, but he knows, okay, or if we accept this contract, mean okay, we can earn something. A business can tackle that, can do. Let's say the principal is not at the office, he's out of the country, and it's difficult for him, for the agent to communicate with the principal, let's say, and uh, we had like give us something like, at least we had just give okay, we'll accept it because that contract is what, like there are a lot of competition for that. So what the principal, what does the agent do? Agent, okay, we'll accept it. And then what is creating? The agency is created only because of a necessity. So he's becoming an agent over there because of what? The necessity. Or else another example is still like this. No, there is a policeman. Okay. And the duty of the policeman, like there is a senior policeman and a junior one. Let's say a traffic police, okay? And the duty of what the senior policeman is just what? They catch the vehicles. There are some of things like not drive properly. That one is the work of the junior policeman. Let's say he is telling the let's say the senior policeman is not there and the road is very much crowded, very much traffic. It's difficult to do so. But his work is not to what? Clear the traffic. Since in order to clear the traffic, what he's doing? He's going doing the work of the senior police. So there, what is creating? He's becoming an agent through what? Necessity. That is not his work. But that's an emergency situation. Or he can't go and call and ask what? The senior policeman, or shall I do this work? He can't do so. The situation is what? In emergency. So that is what? Through necessity. Okay. Now to create. In order to create an agency to necessity also, there should be some conditions. So, like as we think, we can create it. So there should be some uh, conditions. So let's see those conditions. First one is there must be an emergency situation and it is difficulty to what? Communicate with the principal. Okay. Now there should be an emergency situation. Okay. As I told you, the situation should be emergency. Emergency situation. And where you can't what? Talk to the principal and take a decision. Next one is there must be an actual commercial message. Okay. Which means like uh, not a just thing, but something a needed one. Actually a commercial message. I mean some like a record one should be there. I mean like, commercially it's a valuable thing. Okay, it's like a severe need should be there. So something like that. An agent must act in good faith. Okay, now agent, he should act in good faith. No, he should not act what for his benefit. Normally in every relationship, in every There is what agency conflict, no? You might have learned it. So always that will be there, agency conflict. No, if you take what agency means, that word that concept is what running, no? So it's ruling that. So therefore, like when the agent, when he's working upon another person, he should work in good faith. He should be trustworthy. He should be he should be a faithful person, and a believable person. Moment the principal is giving that authority to the agent because of the belief on him, no? So giving big tasks to do so because of the belief, okay, that person will do anyhow, something like that. A fifth one, agent's action must be reasonable, okay, now what the agent doing, it should be reasonable, not a foolish thing. Okay, there must be something, a reason, okay, why this person is doing like that, why that person is acting like that, why that person went to such a contract. It's reasonable. Can we accept that? Is there a reason behind that? Why that person is behaving like that? Something like that. So his agent work should be what? Reasonable. Should be acceptable. The next one. Principal must not have given any prior instruction, which means about the transaction. So about that event. No any prior information is given. So which means the agent, he doesn't know any idea, or he's not having any idea about the transaction that they are gonna do. So let's say if such a prior information is there, means what, agent know what to do, no? It's mean like that's not necessity because he's aware of that, no? Because let's say something, put an example, let's take an example. uh, how can we say that? Now let's say that there's a like salesperson, supplier, okay? I mean, not supplier, procurement manager, purchasing manager. So he's a head, he's a principal, and he is having small other employees working under him. Let's say that's one person who is the one who is like doing what, purchasing. I mean, the who's like ordering items on. So let's say like for him, that okay, every time you have to purchase 10,000 units, something like that. Let's say. So then that person, he will on that date he'll do the purchasing activity, no? I mean he'll make the order. So which means like he's having a prior knowledge about what is his work to be done. But let's say a suddenly an order is there, for that, in order to complete that order, 10,000 is not enough. And let's say he got to you and principal didn't what? Tell him, okay, order more than 10,000. But he knows, okay, if I order 10,000, the I be the what the department, the manufacturing department people, they can't do that activity. So what he will do? He'll purchase more than 10,000. So which means that is created what? Through necessity, no? And like he's not given any prior instruction about that. If he's given the instruction, then he know what to do. Then it won't be what? Through necessity. Okay. Then there are some case laws related to that. GN Railway versus Field, Springgear versus Great Western Railway, Higgy versus Bexplain Stamp and Heacock Limited, Surrey Breakdown Limited versus Knight, Satchers versus Macros. Let's see those case laws in detail. GN Bailey versus Field. So, in this case, A hose was entrusted to a railway authority in order to transmit it from one station to another station. Okay. Now there is one railway station. There's a station one, station two. Now from this station, so what is doing? The railway department station has railway authority, like they have entrusted to a transmit from this station to station a hose. Though the hose reach the destination station, the hose has reached. There was nobody to take the delivery of the hose. From this railway station, now someone should take the hose to what? The what? Right? So, like from the station to station, the hose is ready, but from the station, the hose should be what? Taken to a stable, no? Where it can stay. But what has happened? Let's see. Okay, Robert take and the railway authorities admitted the hose to a stable and supplied food. But no one was there to take this hose. No. Can the hose what go? Can it go? Can it does it have the knowledge what? Like people to go to its place where it had to go? No, right? It will just stay, no? It doesn't know. It's not like human. Then what this station master has did is okay found on his host. So then they have a admit they have sent that host to a stable and they have a supplied food and they have look after the host. A few days later, the owner sought to retrieve the host, nevertheless received to settle the cost of the stable. Now what happened after a few days only the host owner has came and what the railway station, they are like railway authorities telling, okay, we were like looking after your horse for around 2 days and we gave it food and we admitted it to stable. Now you give us the cost. But what does that owner is telling is he said no, we can't do. He's refusing to make the payment. Okay. In an action instituted by the railway to recover the dues, the court held that Railway as an agent had sheltered and fed the horse as of necessity, which followed an agency being created. As a result, owner was liable to reimburse the railway of the expense. Okay. So now what the court is telling is okay, this railway station, okay, they have been what acting as an agent and they have what sheltered your horse, they have like look after your horse and they have given all its necessity and it's you no it's your liability now you should come and have taken the horse at the right time but you was unable, so your work now we need it. Therefore, the court is saying yes, you have to reimburse for that horse owner to reimburse the expense to that person. That's what this case is mentioning. Right. For the next one, Springer versus Great Western Railway. A railway company was appointed to transport a bulk of tomatoes imported in a ship from the harbor to the business premises of S. Okay, now there is a department railway. Okay, and that's a business premise whose business is. And what's this? This is the harbor. Let's write as H. So from the harbor, okay, the good will be coming and it is handed over to railway company. So this railway company is what? They are responsible to transport the bulk of tomato to S. The ship containing the tomatoes arrived the port after a lapse of several days. Now the ship, the what? The ship which contained tomato come now this has reached the harbor uh, not in the right date. Lapse means that it has taken some it's longer. Okay. Since the tomatoes are fast perishing, the railway company sold them at a lower price. Now what is happening now? The tomatoes they are perishing, they quickly get spoiled. So then since these tomatoes has also reached lately, and if that from no they have to clear from the harbor and like A will receive it, and from A then they have to transport it to S. No, then while it is going, okay, it should get perished, and like they are, I mean the S he can't make use of that tomato. So what does this A has decided is, okay, let's sell it. It's gonna sell those tomato at a lower price. An action was instituted by S against the railway company to recover the damages. Now, what does this S is telling to A? No, why did you sold our tomato? Who told you to sold our tomato? Even you have sold at low price, we want the damages. You pay us, you compensate us. What does the court is telling? The court held that as the railway company had known the place of abode of S, the best course of action would be to seek instruction from S. Thus, an agency by necessity had not arisen, and railway company was liable to compensate S of the loss he had suffered. Now, what the court is telling, no. The railway department, they know, no, okay, this ship has arrived lately. So, like, even they know the information. Okay, then what does the best thing the A should did? Okay, they have to inform it to S. Okay, like this only your cargo with tomatoes will be coming lately, so it won't arrive in the right date. So I think since tomatoes are like fast perishing, like what can we do? Something like that. No, his responsibility is not to sell, no, not to do sales. So whatever things they give, they have just transport it. So like no any agency has been created by necessity. So therefore a. The railway company, they are liable to what? Compensate the loss incurred to who? Is. So that's how this is created. Okay. Now the next one. Right. Peggy versus Black Stamp and Heacock Limited. So what about this? An agent has sold a bulk of valuable fur owned by his principal. Okay. Now what's their agent is there here? This agent. He has sold fur to some person. let's say X. So this fur is owned by whom? The principal. Principal's fur agent has sold without his authority. Now he has sold fur to X without principal's authority. The principal haven't told him to what? Sell it, but he has sold it. Okay, the court was of the view that as fur was not of perishable nature, fur can be withheld with the agent until instructions are given by the principal. Now, the court is telling that what fur is not perishing, no? So it's not a perishable item. So then, like agent, like he should have waited, no, until he's getting the instruction from the principal. So say it's not perishable, not quick, it's not an item to be sold quickly. So neither the court is telling. The court ruled that the agent had not sold the fur on an actual commercial necessity for which the agent was liable to indemnify the principal of the loss. No, there is no what? An actual commercial necessity is not there. There is no such thing. Even even the principal also like haven't told to him to do so, and there is like nothing in an emergency situation to do so. Even he can if won't even he can confront the principal as well. And they are specifically mentioned that he is not given the authority to sell that fur, but he is selling that. Therefore, he is doing it with his own decision. No? Then he is the person who is able to what? Indemnify the losses of the principal. So, which means an agency through necessity is not created in this case. Now, the next one. Sorry, Breakdown Limited was not. This case concerned a claim by a garage to recover the cost of pulling a man's car, which had been robbed and hidden. Okay, so this case concerned a claim by a garage to recover the cost of pulling a man's car, which has been robbed and hidden, out of a pawn at the request of the police. When the garage requested for those charges from the owner of the vehicle, he refused settling the bill. Now, what is happening is now one car is there, so that car was stolen, was robbed and robbed. And it was like hidden, and it has what inside a pond. It's a pond. The car is here. So what is there is one man is there, right? And police is there. So what's happening is this police is telling this man, okay, help us to drag this car out from this. So he's okay. He's a garage owner, a person who's working in a garage. Okay, so he's helping to what? Take this car out of the. So now what this garage owner is telling to the car owner, okay, I have used different equipments and I have taken your car out of the pond. You indemnify me. You pay the bill for me. The court held that as there were no emergency situation to hand over the task to a garage without the instruction of the owner of the vehicle, the agency by necessity had to arise. Accordingly, owner of the vehicle wasn't held to be liable to pay the charges of the garage. What's meaning? The court is telling that like there is no like emergency situation, no, it's not emergent to take it out. The police is just telling him to do so, something like a help or something like that, to help us to like take it out. And the like even the owner is also not telling no, not telling to take it. If he is telling me, fine, we can agree. But if the policeman is only telling no, because of the police is telling only he's doing. So we can't go now from the owner, give me the money. So here the court is telling that Even like, yeah, as I told you, even without the instruction of the owner, we can do so. Owner, we didn't ask from the owner, shall I take it or not? The owner didn't instructed the garage to what? Take the car out. The police only told. And also, there is no any agency created over here because of necessity. So therefore, the owner is not liable to pay the charges to this garage person. That's about this one. Next one. Sketches versus macros. In this case, a principal had appointed an agent to collect animal skill on his behalf. Okay. Now the principal, he has appointed an agent, okay, but to collect animal skill. Surge of a conflict between the countries of principal and the agent rendered it impossible to ship goods from one country to another. In the meantime, the agent sold skin at a lower price due to lack of storage facility. Following the end of the war, principal sought to recover the damages caused by the sale of the goods at a lower price without his sanction. By instituting an action, the agent resists the claim, insisting that he acted on necessity. The court dismissed the plea of the agent as he had sold the skin at a lower price due to storage facilities requirement, and it did not project positively on his good faith on behalf of the principal. Accordingly, agency by way of necessity does not arise. Okay, now let's say okay, the principal is there, with the agent is there. Now let's say this agent, so the principal is telling the agent what to sell, me to buy or to collect some animals, and like they had to what ship it to another country. Now the point is the country in which they are gonna what export or to go and sell, it is being conflict. It is having a conflict with another country. So it means that's a problem. There's a war between two countries. So therefore, it's difficult for them to what to conduct the trading activities. Now, what does this agent is doing? You know, he is the one selling all these skins, like animal skin, all those stuff are with him, and he's selling those to another person at a lower price. Now, the principal is asking from the agent once that all done, or is telling, okay, principal is telling the agent, dear agent, go and what? Go in. Okay, now the war is also done. Okay, but sell those skin to that country. Okay, now what the agent say? No, I sold that to another person, and this is the income I got like that. The principal tell now, why did you sell like that? You can't do so. No. So you compensate me the loss. Now the agent is telling that since I was like facing storage problems, so I can't store that. I can't keep those things with me for a longer period of time. That's why I sold it like that. The court is telling that no storage facilities not a positive thing. No, like because of that selling means no, it's agent's responsibility. It's what he should do. If he's not doing that means why he has given the responsibility. So you have to act in good faith. So there is no any good faith in this in agent's activity. Therefore, An agent's asset is not created. Therefore, what? The agent, he is liable to compensate the loss caused to the principal because of his activity. The last, by estoppel, the last way how an agency is created. Okay. Uh, there, when one is declared as an agent, he cannot deny that he is an agent. He should be responsible for all the liabilities. Let's say one person is appointed as an agent, but you're telling you're an agent, you're my agent. Then you can't tell that, okay, I'm not your agent. You can't deny that fact. If you are declared as an agent, yes, you are an agent. You can't what? Uh, you can't tell like I'm not responsible for whatever things you're doing. Yes, something like that. The following requirements are to be met to declare case. I mean, by estoppel, if an agent is created, like this requirement should be what met. The first one is representation by the principal. Like the principal should have been made, should tell that okay, you are my agent, something like that. Reliance by the third party. Okay, let's say like the principal is going to contract with another person. Now the principal is telling to the third party, okay, he's my agent, and the third party also should believe, okay, he's the agent. And affected state of the third party. No, because of like these like trans, because of these agents, like it should affect the status of the third party. Okay, no, that means something like because of this agency, because of this relationship, like he's scared. I mean, he is depending on them. No, he should okay, be okay. Even he's a what agent, I should believe something like that should be there. And case law related that is Freeman and Lockyer versus Buckard Park Properties Limited. Right. So it's the last case law we are going to learn this session conducted by me. Now, X was one of four directors of a company. Okay, there are four directors in the company, and X is one person. X. There are four directors in this company. X is one of the director. X acted as a managing director, though not formally designated. Okay, now this X, he's acting as the managing director. But actually, he's not being appointed as the managing director, but he's behaving like he has been appointed as a managing director. Okay. With other directors not object to the person. Okay. X pretending to be the X pretending to be the managing director of the company entered into a contract with E to draw an architecture designed owned by the company. No. What does this person is doing is like he's the one like who's taking all the decisions. He's not concerned about other like four other three directors. No, he's the one who's doing all those things. And what this X has did is he has gone to a contract with E. He's an architecture. Do something, do a design for the company. Okay. Yeah. With E to do an architecture design voted by the company. In an action, the court opinion that as X had not been formally designated as managing director, he had not no authority to enter into a contract in this nature. Now, this X, although like to other directors, he is acting as a managing director. He is not formally appointed as a managing director. He's not formally appointed, like he's not been appointed as a managing director. So he does not have an authority to what? Enter into such type of a contract. However, the court further held that in this factual context, where the other become the managing director, had not directors by estoppel, therefore the contract entered into by X with E. However, the court held that in this factual context, the other directors had not objected to X acting as MD. X had become the managing director by estoppel. Therefore, the company is bound with regard to the contract entered by X with E. Now, what they are telling me is not okay. Although this person, although this X, he was not been appointed as the managing director, he is not having the authority. But since other directors are believing he is the managing director, they're not refusing, they're not telling anything to him. Therefore, like he's acting like a what? He's acting like a managing director. I mean, he has been created as a agent by a stockholder. I mean, others are telling he is the managing director, although he's not. Others are telling yes. Therefore, like he received that power. No? He's given that position. Therefore, what the court is saying is although it's not given that right, But since other people are believing, okay, he is the what? The managing director, the contract, the X went with E is valid and the company is liable to what? Pay the amount to X. Sorry, E. That's about this one. And I hope all the parts are clear. So now we should learn the types of agent. So that will be told by Sir. If you guys are having any doubts, you guys can upload. I'll be clearing them.
All right, kids. Good evening, everyone. Good evening. Good evening. I think, yeah, the other lecturer, yeah, the madam, she was not explaining y'all a lot, right? She was explaining y'all a lot. Got to explain kara. When I was there in the session, then I had to go out there. And okay, fine, everything was fine. Now, yeah, even here and there, I was there in the session, and everything was good perfectly for y'all. And what is left for me, Lama? Okay, what is left for me is kids types of agents. Even this lama ya puduma mauri mamme illagate like tomorrow illagate I'll start tomorrow illagate so without any further delay kids I'll start it. Just give a sec. I think it's visible. Economic order. Okay, just give a sec. Parliament. So let's start from the type of agent. First of all, we start from where kids we start from mercantile agents, right? Yeah, we start from where kids mercantile agents. So who are mercantile agents? Mercantile agents, Kerala, like these are type of agent who acts on behalf of a principal in compared to mercantile banks. Lamai. The mercantile meaning, like the meaning of the word mercantile itself, it's what Lamai, commercial substance. So mercantile agent means as we were explaining what up calling like yeah, as what uh, like I was not like the other one I was explaining, yes, Lamai. Mercantile agent කෙනෙක් කියන්න ළමයි who is a mercantile agent mercantile agent නෙමෙයි let's first of all start from what අපි agent කෙනෙක් කියන්න පටන් ගමුකෝ agent කෙනෙක් කියන්නේ ළමයි a person who is acting on behalf of it just give a second. Just give a second. Let's see. Otherwise you guys will what uh, sleep. I hope visible. I cannot see myself but yeah hope I'm visible this way. Yeah, Sulamai, once again. Asia comes here. And I should pin myself, right? Otherwise, I won't see it. But I'm good pin it. Okay, fine. So, Lamai, hmm? So first of all, let's start from the beginning, kids. Let's start from the what? Let's start from the beginning. Who is an agent? Agent can lamai. A person who is what? A person who is acting on behalf of a head. Yes, the person who is acting on behalf of head. Lamai, what do you call it? Agent. So specifically, who is a mercantile agent? Lamai, mercantile agent means he's an agent who is what? Who is representing the head in related to a commercial substance. Yes, kids. That's a what? That's an mercantile agent. Okay, kids. Let's move on to what? A broker. Who is a broker? Now, the key point of a broker is, kids, the key point of a broker is even he's an agent. But the key point of a broker is, he is not engaging in buying and selling. Yeah, broker is the person who is what? Uh, Joining the seller and the buyer, Lama. Let's take what? A motor vehicle. Let's take what? In the general sense, Lama. Yeah, let's assume I want to sell my vehicle and I just contract and broker. So what will broker do is he will join me, who is the seller, to my buyer. I mean, he's not engaging in buying and selling. No, he's not what? No, he's not engaging in buying and selling. No, that's not being done. Lama. So kids, what is an like or else who is an broker? Broker is a person who is facilitating a transaction. I mean, he's not what? He's not engaging in buying and selling. That's the most important point. Next one is kid auctioneer. Who is an auctioneer? Auctioneer again, the person who is always trying to sell the products to the highest possible bidder. I mean, in the present context, there are reverse auctions and all those things. But Lama, to be honest, what's an auction? Okay, with an auctioneer, the person who is what? Who is always trying to sell the products of the head to the highest possible bidder. Then Lama, company of like directives of company, partners in what? Partnerships. All those people are what? Agents. Then Lama, who is an general agent? General agent can Lama, he's an agent who is what? Who's having like a fairly substantial amount of responsibilities, which means a huge amount of responsibilities. Yes, kids. He's a what? He's a kid's general agents. And then we are what? Attorney at law, which means a person who is representing in legal scenarios of on behalf of you, something like that, Lamai. So hope everything is pretty much clear. Once again, a quick question: agent kya kya hote Lamai? Agent kya a person who is not acting on behalf of a head, Lamai. A part who is acting on behalf of it. So kids, starting from broker who is a sorry, starting from mercantile agent who is a mercantile agent, kids. Hmm? Who is a mercantile agent? Who is a mercantile agent? Kids, mercantile agent can agent who is what engaging in a commercial substance. Once again, like uh, in a commercial substance means representing the seller in a what commercial substance. Yes. Okay, I'll try to. Yeah. Then my broke is a person who is what? Who is facilitating a transaction between a buyer and a seller. My auction is the person what uh, highest possible bidder to my or product is selling an auction. Yeah, then lama who's a director of a company. Director of a company means lama like someone who is what representing on behalf. Like for example, when it comes to companies, lama when it comes to companies, the key characteristic of a company is lama the ownership and the management is separated. So the management is done by directors, which is appointed by shareholders, and the ownership is held by the uh, owners who are the shareholders. So kids, they are the directors of a company, act as the agents of the owners. Lama. Then general agent is an agent who is what who has a fairly substantial amount of responsibilities. Then we have attorney at law, a person who is not representing you in legal scenarios. Alright. So kids, I think agents are almost done. I'll what go to next part. Yeah, I'm liable to what teach y'all today. So let's move to next one. Just give a sec. Just give a sec. All right, kids, I'll start insurance then. Just give me a sec. This part is being shared, so I'll what expand this, otherwise there'll be a small issue. Now it's fine. Now it's fine. Everything is fine. A small issue, am I? Okay. Now everything is fine. So kids, first one is okay. Okay. Now today, now in this session, we'll be learning about what kids will be learning about. Laws related to what? Laws related to insurance. Up insurance can you come? Let's talk about insurance. It's a nice thing. Okay, insurance personal, but it's a part where I prefer the most. My personal, my kyavathiya part is my insurance. Yeah, I just prefer insurance. I don't know the reason, but I just what prefer insurance. Okay, let's start from the beginning. The first question is what is insurance? Okay, before moving forward, Lama, you should know what is what? What is insurance? Kids, what is insurance? Lama, it is an agreement between insurer and insured, whereby insured agrees to pay the premium and insured agrees to what? Pay the compensation that insured face from the insured is okay. It's a nice thing. Insurance ki anne lama, insurance ki anne. I mean, kids, it's a written agreement. It's a what, kids? It's a written agreement written between two parties. Insurer, hmm? Insurer. Now you might be asking who is insurer. Lama insurer can the person like who is simply applicable insurance company. That's very easy. Okay, insurance company, insurer, and insured the person who is not obtaining the insurance coverage, which means you, Lama. So what is insurance? It is an agreement you create with the insurance agreement. whereby you agrees to pay the premium. So the next question is, what is premium? Premium is the amount of money you expect to pay, Lamai, to obtain the insurance policy. Yes. And it's insurance company agree to pays you the compensation. Like if the insured face the what damage from the insured risk, only from the insured risk. So what is insurance? Insurance is something very interesting. It's an agreement which happens between you and the insurance agreement, sorry, insurance company, whereby you agrees to what? Like pay the premium. Premium means it's the amount of fund you agree to pay to obtain the insurance coverage, and they agrees to pay you the compensation, or else the insurance company agrees to pay the compensation. If the insured what face the damage from the insured risk. Okay, next one. For life, yeah, for fire, for life and marine, yeah, English law is applicable, and for others, Lamani, Roman Dutch law is applicable. So when we talk about the legal system of a country, kids, when you talk about the legal system of a country, kids, when you talk about the legal system of a country, Lamai, the legal system of a country, kids, or as the legal system of the world can be mainly categorized as English law and Roman Dutch law. Yes, Lamai, the legal system of the country, the legal system of the country can be mainly categorized as what, Lamai? English law and English common law and Roman Dutch law. Like mainly you can categorize it as that. Oh, yeah, me. English common law can it's originating in Great Britain, then law Roman Dutch law, Lama, it's a written law, okay? So most people via life, what am I use usually what will be applicable? For them, Lama, mostly what's applicable. Roman Dutch law is only applicable. Yes. Next one. Nice, interesting, interesting. So, Lama, if you have any doubts, you can ask it in the group. It's group means like in the YouTube chat portal. Elements of insurance contract, or as Lamai, the real what real thing for this is Lamai, like what are the steps that should be followed? What are the steps that should be followed to create to validate an insurance agreement? Yeah, to valid, like what are the steps you should follow to validate insurance agreement? So kids, what are the steps? First of all, intention to create what legal obligation. Next, Lama, insurance offer or proposal. Next one is acceptance. Next one is what, Lama? Legal validity. Next one is competent parties and consideration. It's interesting, Lama. It's interesting. It's interesting. So if I explain this in a what more familiar manner for you, if I explain this in a what for familiar manner for you, Lama, these are the steps that should be followed in order to what validate your insurance agreement. Oh, here they talk, yeah, they are specifically mentioned as elements of an insurance contract. So when it comes to insurance, it happens in three steps. I'll explain you all perfectly. I'll explain you how kids perfectly. I'll explain you how kids. I'll explain you all perfectly. Now I'll listen to explain. When it comes to Lama insurance, the first thing that should happen is insurance proposal. What is the first thing? Insurance proposal. The first thing that should happen is Lama insurance proposal. Yes. Next one is Lama insurance agreement. Yes, that's the second thing to happen. The final one is Lama. Final one is. Final one is insurance certificate. Insurance what? Certificate. And like when it comes Monna insurance, it might be what kind of insurance, yeah, we don't care. It happens in three steps. First one is you do the what, proposal. So proposal can like it's a what it's a request made by us to the insurance company to obtain the insurance coverage. So you might be wondering, so all of a sudden why are you teaching those things? Lamine, first of all, we should have the intention to create a legal obligation. You know it's an obligation, right? It's a risk. It's a responsibility. Being bound to do something to some person. That is what a legal obligation. So, Lamai, like when it comes to obligations, you have two types of obligations. We have constructive obligations and we have legal obligations. Constructive obligations are the obligations which are arose from entities actions, derived from entity actions. Like they are unofficial obligations which change from time to time. So those are what lamani, those are what kids. What can you call it? You can call it constructive obligations. So, what is legal obligations? Legal obligations are, I mean, like these are the official obligations which cannot be changed from time to time. So, my first one is to create a legal obligation, which means yeah, like you accept the responsibility to pay something to some person. Ulama කියන්නේ, willing to pay the premium. Proposal like proposal like proposal like දාන්න කලින් ළමයි propose then දාන්න ඕනේ ළමයි like when if I want to obtain an insurance coverage ළමයි I know I have to pay a premium so I should accept that legal obligation then I should make a offer the proposal I should request ළමයි then they should accept it then ළමයි legal validity කියන්නේ like they'll check whether it's suitable to give me a particular insurance coverage and all those things are done then ළමයි the next one is competent parties means like the other party also should what agree for like to bear the obligation, which means my even the insurance company should agree to what? Insurance company should agree to pay the compensation. I mean, acceptance of the obligation by the other party, or you call it competent parties, like the other party also should accept the obligation. So second step එකේ මොකද්ද වෙන්නේ proposal එක අරන ගමන් කෙලින්ම ගැව්වා ළමයි මොකද්ද agreement එකක් ඔය agreement එක ගහන්නේ insurance what insured is agreeing to pay the premium insurance companies are agreeing to pay the compensation then ළමයි consideration which means the amount that is being exchanged all those things should be what I mean those are the elements of an insurance contract yeah who are the competent I mean like legal obligations the offer acceptance legal validity, competent parties, consideration, all those things. So, now what are the three parties related to insurance agreement? Yes, we have the first party. First party means you call it insuree or insured. You call it insuree or insured, the person who obtains the what? Insurance coverage, or the person who creates the proposal. Then second party means insurer, the insurance company accept the proposal. Third party means any parties are affected through the insurance agreement. Fine. Come on, kids, I have to do everything for you, right? Proposal and covenant. What is a proposal covenant of insurance? I mean, first of all, let's talk about the contents of a proposal. I have told you, like when it comes to insurance, Lamai, the fundamental idea of insurance is you have three parties: first party, second party, third party. First party means the parties what accepting the insurance. I mean, like sorry, the parties are uh, providing the cover, maybe sorry, requesting for the coverage or we simply we API insure you call it insured or you call it insuree. Then second party will be the insurance company, the insurer, the person is not providing the coverage. Fine. Then third party can any other parties related to insurance. Then what is insurance? It's an agreement between you and the insurance company whereby you agree to pay the premium. You see, okay, I'll pay the premium. The insurance company, they'll what? Agree to pay the compensation, which means the amount of refund they give you to what? Reinstate your damaged property to the original state. So kids, I told you all it happens in three steps. First of all, you have the proposal. Proposal means you are a request. And if it's valid, they accept it. Then they prepare the agreement. Then I think third one, I was like, well, like, what is third one? I said it's insurance certificate, right? Insurance certificate, it's the certificate which is given by the insurance company to the insurance company to the insured or the person who obtains the coverage or us after the insurance agreement after the agreement the certificate or the document the written evidence which is given is known as what from the insurance company is known as insurance what you call it insurance policy or insurance certificate yeah you call it policy can have insurance certificate the real name is insurance certificate. All right, so hope what that part is very clear for you. Interesting. So if you have any doubts, yes, you may what request it from me then and there. I'll be what then I'll be balan and then with up YouTube big avilla. I'll just what refer through the YouTube. Just give me a second, give me a second, give me a second. No doubts, right? Okay, fine. If you have doubts, yeah, please do request it. Right? Next one, Lama. Yeah, okay, like, okay, what are the contents of a proposal? Okay, Lama, they are saying, Lama, description of the proposed, I mean, like name and address of the insured, yeah. They'll have a description of his rights, then Lama circumstances, then Lama previous history about what the proposed issue, then like all those things, Lama, yeah, all those things are available. Then we cover note can it's a temper note given by the even I have received a cover note. It's a Lama, temporary document which is given by the insured until what making the proposal permanent. Yeah, my proposal like my temporary issue a document cover note. Even losses occur during this period using the cover note, insurer cannot. I told you right, like, my insurance certificate will be issued after the insurance agreement and all those things. Now still we are in what proposal thing. So the put lamar of temporary the document it's cover note. Basic classification of insurance. We have indemnity insurance and we have what? Contingency insurance. So kids, what is indemnity insurance? I can more. Those things are. I mean, like if you talk from A level perspective, it's categorized as when it comes to insurance policies. When it comes to insurance policies, how can we categorize insurance policies? Hmm? When it comes to insurance policies in A-level, how are you categorizing it? A-level को कैसे categorize कराने? A-level categorize कराने की we categorize it as on one hand you have what general insurance policies, on other hand you have the life insurance policies. I mean general insurance policies are known as short-term insurance policies, life insurance are known as long-term insurance policies, or as life insurance are also known as assurance. General insurance you can also call it property insurance, but I don't prefer it, but yeah, you can call it. Yes, kids. Yeah, based on what? Based on A-level context, my insurance policies. How can we categorize it? General insurance policies and life insurance policies. General means my PPE or property, plant and equipment. You call it short-term insurance policies, and on the other hand, you have the what? Assurance or life insurance or long-term insurance policies. Next one. So, okay, but the problem in double it, let's say. So, when it comes in indemnity insurance, in indemnity insurance, compensation is paid for the what losses occurred to the insurer. Is here the only the damage value will be compensated. Insurer agrees to pay the agreed amount irrespective of the value of indemnity. You know what's indemnity principle, right? So now the most important thing is doing what when it comes to insurance. I'll write it here, kids. When it comes to insurance, Lamai, when it comes to insurance, insurance has Lamai policies as well as principles. Insurance has what, kids? Are right here, kids. Insurance has policies and principles. So what is policies? What are insurance policies? Lamai policies means like the coverages you have. And how can you mainly categorize it? You have the general thing and the life insurance. General is also known as long term, sorry, short term, kids, you call it property insurance, like a life insurance, you call it assurance. Next one, kids. Next one. So then on the other hand, we have principles. We have what, kids? Principles. We have principles. So now when it comes to principles, how many principles we do have, kids? We have six principles. I mean, principles are means rules and regulations used in yeah. Simply, if you ask me, so what is principles? Lama principles can rules and regulations used in insurance? They're like what rules and regulations used in insurance. That is what Lama principles. So what are the principles available in insurance? May I know the answer? So the principles available in insurance are, kids. You have, okay, I'll teach nicely when it comes to principles now. You have, let's start from insurable interest. Insurable interest means අපි ඉස්සරහට ඉගෙන ගන්නවා kids in the future will be learning insurable interest means the legal right you have to insure something. Then we have the utmost good faith. Yes, both parties disclosing the true information. Then we have the proximate cause, lamai, the immediate reason for the damage. Then lamai, we have indemnity, subrogation, and contribution. Now, the most important thing is kids out of those insurance like principles. So once again, what is policies? Policies means various what coverages. We have general and the life one. So principles means rules and regulations. So like, we have insurable interest, we have utmost good faith, we have what approximate cost. Apart from that, we have indemnity, subrogation, and contribution. And all these six insurance principles, yes, they affect general insurance policies. Yes. But for life insurance policies, only insurable interest, utmost good faith, and proximate cost affects for life insurance, which means indemnity, subrogation, and contribution is not affected. So the next question is why is it? What is indemnity? Indemnity means when a property or something is damaged, the compensation will be given only to reinstate the damaged property. Yeah, only to reinstate the damaged property. That is indemnity is saying. At the end of the day, the final what? Final word of indemnity is through insurance, no one should earn profits. Through insurance, no one should earn profits. So, Lamai, that's why in indemnity insurance, Lamai, here the compensation will be given only what? Only if the property is damaged. Hmm? Usually, Lamai, these indemnity insurance principles are taken for 1 year, and within that 1 year, if your property is not damaged, kids, you will not get the compensation. Yes, yes. And Lamai, compensation will be what? Only received to the like, amount of damage that has happened. But contingency, example, life insurance. In life insurance, indemnity is not applicable. Indemnity, subrogation, contribution is not applicable because the value of life is immeasurable. Indemnity can give when a property is damaged, please give compensation only to reinstate the damaged property. Huh? Just don't what give an amount which is more than the damage. Just what if you insure your motor vehicle for 5 lakhs, let's assume 5 lakhs, and the damage is 2 lakhs, you get only what 2 lakhs according to Indian principle. That's it. ඊටට දෙන්න සතයක්වත් දෙන්න. කවුද කියන්නේ? None other than who is it? Who is telling that? Our friend, indemnity. But the problem is that applicable for life insurance? No, it's not applicable for life insurance. Why is it? Because the value of life is immeasurable. කොච්චර සල්ලි දුන්නත් ළමයි, if you die ළමයි, if you die, කොච්චර සල්ලි දුන්නත් ඔයාලේ negative නෑ. Are we clear? Yeah, clear. Right? Hope everything is clear. I mean, so what is contingency? Contingency, yeah, like which means insurer what agrees to pay in like irrespective of the loss, yeah, full amount given. Entire policy amount or the pre-agreed amount will be paid. Anam manam bayilada. Agreed amount yeah, given no bayilada na damage value එක කීයද මොකුල් වැඩක් නැහැ. I think every part is clear there. Principle. Okay, we are going to principles of insurance. Yes, ladies and gentlemen, what are the principles of insurance? So I have told you. What I get last again, what are the principles of insurance, kids? We have what? We have insurable interest, utmost good faith, proximate cost. We have indemnity, contribution, and subrogation. Out of these, what? Out of these six, only these three affects what? Life insurance. Insurable interest, utmost good faith, and proximate cost. What about indemnity, subrogation, and contribution? All those three are not applicable for insurance or life insurance. But all six are what? Affecting general insurance. So now what is the insurable interest? Insurable interest, it is the legal right where you have to obtain insurance policy for a particular person or a property. For example, can you insure Yagidra Pusa? Can you obtain insurance coverage for Yagidra Pusa? No, because you don't have the legal right. It's the legal right you have to insure a particular person or property. Yagidra Pusa insure කරන්න බෑනේ. Hey, because Yagidra Pusa Yagidne me. Can you insure your vehicle? Yeah, your vehicle you can insure. You can insure your vehicle, no point, no issue. You can insure your vehicle because you have the legal right. You have the ownership. So if you ask me, sir, like, what was it? Sir, කොහොමද ඔය දැන් මෙහෙමයි like මට simply I can tell now interval interest means it's what it's a legal right a particular person has to what interest something. So like, sir, කොහොමද sir, how is that legal right being formed? Right. If the existence of something provides economic advantages and losses to it provides economic disadvantages, yes, Lama, that particular person has got insurable interest over it. For example, if I have my motor vehicle, I can use it for traveling. That's an economic advantage. And if a damage happened, I'm on the pole giddy. No, that's a what loss. So that's an economic disadvantage for me. So like in such a scenario, I have the insurable interest for that object, which means I have the legal right to obtain insurance coverage. Balanda, what is insurable interest? It is the legal right you have to what? It is a legal right you have to obtain what? Like it's the legal right you have to obtain what coverage for another person or property. So and that right is created if the existence of that object is an economic advantage for you, and if it's a if a disadvantage happens to it, if it's an economic disadvantage to you, right, you have insurable interest to it. Yeah. So we can go to cases like there'll be what we India and London insurance assurance. Then now we have Banforth was what Saunders. Then we have Griffiths and Fenning, and we have a famous case. I mean, තනි මේ තනි පට්ට වරණයි පට්ට වරණයි නේ වරණයි සාමාන්‍යයෙන් මේ මං හිතන්නේ ළමයි most මට නම් මෙතන මම හිතන්නේ I think these are common law cases. Common law cases. Yeah. Roman Dutch නෙමෙයි common. Yeah. කියන්න පුළුවන් cases. And yeah, life insurance is mainly based on common law. That's what we learned. Interesting. Interesting. And ළමයි like මෙතන මේ in what? In in the Indiana what? Uh, There'll be India and London insurance assurance එක කියලා තමයි credit as what an ins an insurable interest to the life of debtor. එහෙම මෙහෙමයි මේ ඔක නම් දැන් ආගියබල් අර ඔතන concept එක ගේන්නේ මේකනේ ළමයි. ඔතන concept එක ගේන like for example ළමයි when it comes to a debtor, debtor is a person who should pay some amount to the creditor. I mean, who is a debtor? A person who is payable some amount to the creditor ළමයි. So like දැන් හිතන්නකො kids that person died කියලා. එතකොට අරට සල්ලි හම්බෙන්නේ නැහැ නේ. ඒක අර කියන්නේ credit has what insurable interest of the life of a debtor කියලා. But I won't personally agree for that. දැන් නම් මං හිතන්නේ මේක ගොඩක් overrule වෙලා ඇතිලා. This case might have been overruled. Personally හිතනවා මේ with due respect. I would personally say a creditor has an insurable interest over the amount the debtor should pay, but not over the life of the debtor. මං හිතනවා personally මේක වෙනස් වෙලා ඇති කියලා. I think what might be changed. Yeah, I think it might have changed. මං හිතනවා වෙනස් වෙලා ඇති කියලා. Next one, Lamai banned fourth and yeah, Sounders. A guarantee of a debt has been an insurable interest in the life of principal debtor. Yeah, once again they talk about that, Lamai. But me බලන්න cases යන්නේ 1970 ගණනක. At the present context, I think Lamai may not based on the like for example, creditor has an insurable interest over the amount the debtor should pay, not the what life. Huh. But that depends on the cases. A person has an insurable interest of his what own life, and one spouse has an insurable interest of the life of yeah, like Griffins and Felini like for example, the facts of the case put up Balagan kids are just for the facts of the case. So the like also, like at the end of the day, the judgment is what we can extract from that case is kids. A particular person has unlimited. For example, I have the right to insure myself because the existence of me is an economic advantage for me. And something happened to me means it's an economic disadvantage for me. And the spouse means your wife or husband. Now, to be honest, there is an insurable interest over husband and wife and husband and husband, which means husband can obtain an insurance coverage for the wife and wife can obtain insurance coverage for the husband. But Lamai, if the children are above 18, if the children are above 18, parents can't obtain what? There is no insurable interest to parents and children. Once again, if the I'll explain it nicely. මේ බලන්න මේ cases ටික ළමයි in India නා case ළමයි they are saying a creditor has got an insurable interest over the life of debtor. ඕක වෙන්නේලා මෙහෙමනේ. Debtor is a person who is liable to pay some amount to the creditor නේ. Pay කරන්න බෑ some amount එකක්. And like since if something happens to that person's life ළමයි that person will not receive that amount. So ඒකයි කියන්නේ. Then ළමයි මේ Banford case එක කියන once again a guarantee of a debtor. like for example guarantee එක විදියට අස්සම් කරපු එක්කෙනාටත් ළමයි insurable interest එකක් create වෙනවා like එයාටත් insurable interest කියන්නේ which means එයාත් liable වෙන කතාවක් කියන්නේ වා ඇත්තටම for example I'm gonna take a loan from bank ළමයි okay and they'll not what obviously give me නිකන් දෙන්නේ නැහැ they'll ask me guarantor so guarantor එකක් ළමයි යා අස්සම් කරනවනේ මම so which means if I did not pay the money who should pay the money guarantor should pay the money there is a contingent liability there for the guarantor. Now, the example like it's I go to the bank and obtain a loan of 50 lakhs, and they'll obviously ask a guarantor to sign on behalf of me, which means, and at the end of the day, if I'm not paying that 50 lakhs, if some amount is payable, the guaranteed person should pay it. It's not easy because he's agreeing, you know. So it's a contingent liability, not a liability, but it's a contingent liability for that guaranteed person. So you know what's a contingent liability, right? Those are possible obligations arose as a result of past transactions, and whose what existence will be confirmed through the occurrence and non-occurrence of future uncertain events, which cannot be controlled by business. Which means it's not a liability for that person. The guarantee that it's not a liability for him because it will become a liability. Liability means it's a present obligation arose as a result of past transaction. If there is no present obligation, I mean, that person is not liable to pay at the moment to the bank because I'm still paying it. But it's a contingent liability. Means there is a possible obligation. I mean, a possible obligation arose as a result of past transaction, and the existence of it is confirmed through the occurrence and non-occurrence, which means if I pay in the future, it will not be an obligation. But if I did not pay Lamai, that possible obligation will be converted to present obligation. Hope everything is clear. Interesting, right? Yeah, interesting. Can dance. Then we give Lamai, oh, sorry. Next year, the Griffins again, Lamai person has unlimited insurable interest over his life. Obviously, Mata Marvin Chokaranda with the Papa the Marvin Chokaranda. Then Lamai, next one is yes. Husband has the insurable interest over the wife, and wife has the insurable interest over the husband. Because like for a husband, the existence of wife is an economic advantage. Ne? I mean, she'll be a what? Sometimes if she does a job, it's an economic advantage. Even if it's at home, she'll be what contributing economically. Obviously, you can't tell that fact, and vice versa. For wife was the existence of husband is an economic advantage, and if something happens to the husband, the economic disadvantage is for the wife. So there is an insurable interest. But Lama, if the children, I mean, there is no insurable interest among parents and children, Lama, specifically if the children are more than what, 18 years old. So when you're more than 18 years old, Lamai, in front of law, you receive the legal capacity. Legal capacity means you can conduct legal transactions by your own. So what is legal capacity? Lamai, legal capacity means it's your ability to what? Conduct legal transactions by your own name. So according to Sri Lankan law, Lamai, age of majority act, Lamai, you receive what? You receive the name. A legal capacity හරිම ඔයාලා legal personality කියලා අහලා තියෙන්නේ legal personality නැත්නම් legal capacity කියන එක ළමයි the concept legal capacity and legal personality receives for you when you're more than what 18 years according to Sri Lanka age of majority act. So which means what is legal capacity or legal personality? I mean your name will be considered what as a separate part in front of you. So when you're more than 18 years old ළමයි without your consent ඔයාගේ අස්සන නැතුව your father or mother cannot what obtain an insurance coverage fee. Because Lama, there is no insurable interest. මොකද ළම වාහි ටික කියලා වගේ අම්මා තාත්තට it's not economic advantage. I know that. I mean, ඒව direct එකක් නෑ නිකෙක්. There is no, I mean, ළමයි there is no insurable interest to blood relations. එහෙම අර මල්ලි අයියා අක්කා නෑ නෑ those shit are not there. No. Or blood, like for example, you cannot like ඔයාට ඔයාගේ මල්ලි වෙනුවෙන් insurable interest එකක් ගන්න. I mean, like, yeah, you don't have insurable interest to your brother, father, brother, sister, whoever it is. And lamai, the most important thing is me. The lamai kanga sir, what if the child is less than 18 years old? Then you podi vayase wage nangi tin lamai ni. Kana di ganda puluwan iti ekka ප්‍රශ්නයක් නෑ because I mean හැමෝටම ඒත් බෑ ළමයි. The like like for example if you are with your parents ළමයි you are under their custody නෙමෙයි. According to custody of this laws ළමයි yeah. එතනදී if you are less than 18 yes without the consent can. ඒ මං කිව්වේ ළමයි insurable interest is not there between parents and children when children are more than 18. For example අඩුම ගානේ මේ when your parents open what අම්මලා තාත්තලා open කරනවා ළමයි නෙමෙයි like පොඩි කාලේ accounts open කරනවා and you can obtain the money when you're above 18 years old ළමයි and ඔයාලා දැකලා තියෙනවද in such a scenario ළමයි if you did not sign me then sign කරන්න දෙන්නවා your parents can obtain the money because you have received the legal personality. Interesting right? लेकिन utmost good faith kids utmost good faith කියන මහ ලොකු දෙයක් නේ both I can talk about a lot about insurable interest even now pawn brokers have the what insurable interest over the pawn goods. Even lamai lessee means in leasing law lamai who is lessor means the leasing company lessee means the person who is what leasing it out lamai lessee have the insurable interest over the what lease goods which means lessee has the right to what insure it. Then lamai me. Ship captains have the insurable interest or the ship goods lamai. But lamai, a tenant has no insurable interest over the me. Rented goods or tenant. Rent karapu kinetta lamai, no, there is no insurable interest. But lessee lamai have. I'll stop from there because it will be too much fair. Yeah, utmost good faith means that both insured and insurer should disclose all the material. Material can like once in material, the important information faithfully. Hurry disclose down. In Lamai Lockerbie, Low Union Insurance Company, London Assurance, Menzel, yeah, then Lamai Bulgians and Ceylon Insurance, okay, yes. And if there is what a representation is innocent of, yeah. I mean, he might like if the material misrepresentation, I mean, like if the material misrepresentation, like for example, someone has bleached the insurance in utmost good faith කියලා. So maybe I think like it might be innocent දන්නේ නැතු වෙන්නත් පුළුවන් negligent ඉඳ වෙන්නත් පුළුවන් ඕන කමින් වෙන්නත් පුළුවන්. I mean the insurer can reject it. It's අගතේ තියෙන. Easy right? It's interesting කියන්නේ කිසු කියලා අපි හිතලා බලමු මේ. Like these utmost good faith thing means lamai can you remember there will be an agreement created between insurance company and the insured whereby insured agrees to pay the premium insurance company agrees to pay the compensation. So I'm to decide the premium I'm to decide the premium and to do the what other things the premium එක decide කරන්න ඉතුරු ඔක්කොම කරන්න ළමයි both parties should disclose the information properly. For example, let's assume I'm going to what? Janashakti Insurance Company to obtain a life insurance killer. So then I should tell all my what? Sicknesses. Then you might be thinking, sir, as a what? Insured, why are you not telling all your sickness? The more sickness you say, Lama, the risk of your life is high. So the risk of your life is high, and the premium will be high. You have to pay more money. Is it picking? Sometimes in what? In motor vehicle insurance, some people they just value the what? Value the motor vehicle at a lesser amount. The reason for that is if the valuation is low, insurance what? Insurance premium will be low. But the problem is then have to done already. But the premium you're paying is low. But other person then the compensation will be what really high. Oh, that for a fact. Interesting, right? Interesting, right? Very interesting. So Lama, what people does it Lama, they'll contact the valuation companies and they'll value the motor vehicle at a lesser price. So when they value the motor vehicle at a lesser price Lama, The when you what when everything I value කරන insurance companies වලින් valuation එක they'll tell us to what give them. Hardly sometimes, yeah, if the motor vehicle is so worth and so value, එතකොට ඉතින් like you, yeah, they do it separately. But normal vehicle වල එහෙම නෑ නේද? But මෙහෙමයි they'll consider market what. Market value අර එහෙම ඉතින් බොරු කරන්නත් අමාරුයි ඉතින්. ඉතින් මෙහෙම ඒකද ඉතින් බොරු කරන්න අමාරුයි ඉතින් අර යාලා දන්නවා ඉතින් bleach කරොත්. I mean, they know if you bleach, but it happens අර ලක්ෂ 3-4 වෙනවා ඉතින්. And හිතන්නකො ළමයි like a vehicle which is worth 80 lakhs ළමයි you take a valuation for 60 lakhs like it's anyway it's bleaching utmost good faith. So ළමයි then they'll say the premium a low premium and you pay a low premium and if your motor vehicle is damaged ළමයි no the spare parts and the I mean if you have put it fully insurance specially yeah කොහොමද එන්නේ? Still they'll give it. But that's what you're breaching utmost good faith. You have not what disclose all the relevant material information properly. Now let's talk about what insurance company can do if you have breached the utmost good faith. Simply can file a court case. Just can file a court case. Anything. Then I can what? Simply ignore. Then can give a verbal warning, can give a written warning, refuse to pay the compensation. Yeah, are we clear? Yeah, in filling out what insurance proposal form lamane, Locker did not disclose that he was what badly attacked from pneumonia. At the end, life insurance, yeah. After obtaining the policy, he died due to what second attack of pneumonia, but compensation, I mean, what is that is amount is not disclosed. I mean, and company could what refuse to honor the policy. Am I mean? Giving like he should simply බලන්න in filling out what the insurance proposal Locker didn't what disclose that he was not okay. He is not due to some reason but එයාගේ intention එක දන්නේ නැහැ ඉතින්. මොකද Locker දැන් මැරිලානේ ළමයි. Locker has not indicated that he is attacked by pneumonia. So after obtaining the policy was he has died due to a second pneumonia attack. Court decided what? That this amount to a non-disclosure. I mean like not disclosing a matter. Material fact කියන්නේ anything. And the company should what? Refuse to honor. And company could what again like it's an interesting thing. Like for example, let's take me. I have what? Let's say I have pneumonia badly, and I'm going to obtain an insurance coverage now, and I'm not mentioning that I have pneumonia. One pneumonia, I would say that I have pneumonia. Fine. And the premium will be also low. And after what 1 year or 2 year within the policy period, I die. And I died due to a pneumonia. But the policy was life insurance policy was obtained for me, not for pneumonia. Let's say I have obtained it for diabetics or something. Now here I have died due to pneumonia. Now the proximate reason is not covered by the what? Insurance coverage. So you know what's proximate cause, right? Proximate cause is the immediate reason for the damage. So the immediate reason for my damage is pneumonia attack, and I have not included pneumonia attack under my what risk in the insurance coverage. මම coverage එක දාලා නැහැ. ඔය දාලා නැහැ ඉතින්. I have not insurance. So so yeah, in this situation, what has code does it lamai? And the most important point is lamai here, Locke has died in this movie. No one is what there to speak. I mean, there might be a particular person who is speaking on behalf of Locke, but Locke is not there. I mean, we don't know the intention why Locke did not mention that pneumonia thing lamai. Whether is it what to decrease the policy amount? I mean, we don't know his intention, right? We don't know whether it's what bona fide intention or mala fide intention. Bona fide means good faith, good intention. Mala fide කියන්නේ bad intention. Yeah. I mean, like in this world, I mean, no one is what sadasotti ne, sadasotti. Like no one is what perfect ne. I mean, we don't know the intention, and no, I can simply say Mr. Locker might have what that might happen. What negligence because වැරදිලා කියන්නත් පුළුවන්. If not, I can say another person can argue නෑ මෙයා මේ ඕන කමින් කරලා තියෙන්නේ මෙයාගේ මේ ප්‍රීමියම් එක අඩු කරගන්න. ඕක කැන්සේ මේ. කැන්සේ අපි කැන්සේ ඕක කැන්සේ it's interesting right to බලන්න like යාගේ it's interesting. So in so court what has court done is now they have recognized it as or not disclosing a material fact and they have told the company with they cannot either provide compensation or not providing compensation. It's a nice thing. Kids next to London Assurance versus Mansell. What is meant by that? Mansell applied a life insurance policy in filling out what the application form. The question as to what whether he had applied to an other insurance company for such policy. He answered that he had already got has such policy with other insurance companies, but he revealed the application that his application for life insurance had also been rejected. Ah, okay. And its company is rejected due to reason. Okay, held Mansell has failed in its duty of utmost good faith disclose metal fact. Therefore, once again, මෙතන මෙහෙමයි like there's an there's a case between an insurance company and what a particular person. That particular person is going and asking an insurance coverage from London insurance company, and that insurance company is asked whether Mansell has obtained or requested or have other insurance. I mean, other insurance policies from other companies. And Mansell කියනවා ලස්සනට මෙහෙමයි. I have applied. I already what, have two policies with other insurance companies. But that bugger is not telling those insurance companies have rejected the offer or the proposal. මොකද එහෙම ඉතින් like එහෙම ඉතින් Mansell like you might be wondering so why Mansell is doing like that. ඉතින් එහෙම කියපු ගමන් ඉතින් London Assurance will be like afraid. One thing is London Assurance will be afraid to give a policy for Mansell, or else London Assurance will what start a investigation as to why those companies have rejected it. Next one. Interest. And we had another case Lama. It's yeah, maybe the Ceylon. Yeah, okay, it's a Ceylon insurance company. Okay, it's a Sri Lankan thing. The insured means the person who obtains insurance coverage who has what been convicted to 20 years for a technical offense has answered no to the question. Have you or any person who will drive being ever convicted for any offense in connection with the driving of motor vehicle? The Supreme Court held that there is no material non-disclosure as the question was ambiguous and like a trap. Yeah, yeah. I get your insurance company බඩ කරනවා කියලා. මාණ්ඩා. The insurance company, sorry, the insured can lie the person who is opting the insurance company who had been convicted for 20 years for a technical offense. Sorry, technical offense again, he has been convicted, been sent in jail for 20 years, has answered no to the question. No, Kiranamai, have you or any other person who will drive, who will drive, being ever convicted for any offense in connection with the driving of motor? I mean, like, what the hell kind of question is that? I mean, come on, kids. I think Sri Lanka insurance company B line the okay, there is a person that Bhaga is convicted for 20 years, like that, and that has happened due to a technical offense, due to a technical misrepresentation. That person has been convicted at 20%. That 20 years, that's a different story. And what happens here is like he has answered no to the question. Have you? I mean, oh yeah, or any other person whom you might know or any other person who will drive being ever convicted to what? I mean, how do we know? මෙතන Supreme Court එකේ කෙලින් කියන නෝ මෙහෙමයි. There was no material මේක ඉතින් මගෙන් යවුවොත් මම yes or no කියලා ඉතින් based on the context I don't know what the they're trying to ask. So since the question is ambiguous, yeah, එතන like එතන මේ The insurance company is liable like then Malibu company naman. In what filling the terms of okay insurance mistakenly mattered that what BIR pads on okay okay where the actually parks on the sheet. Yeah, so once again when me material representation misrepresentation like in the compensation given back in. Yeah, they're saying cannot be what compensation like given back like or because necessary information and nothing that yeah one can like I mean, material the non-material the I mean, material mainly material only whether it's what negligence or fraudulent yeah compensation will not be given. So the final things for that. Proximate key cause. What is proximate cause? Okay, Lamai. When a property is damaged, Lamai, when a property is damaged, there might be what, several reasons the property is damaged, but but what is proximate cause, Lamai? Proximate cause kya hai? What is proximate cause? Proximate cause kya hai? Out of the several what reasons that can cause damage, Lamai, the compensation is paid only for the risk that is covered in the policy. I'll take a nice example for this. I'll explain you all in a nice manner. Yeah, I'll just explain in a nice manner. This proximate posting. It's an interesting level. Let's assume, Lamai. Let's assume me. Let's take me. Okay, I'm a person who have diabetics, Lamai. I'm a person who has what? Diabetics. Yes, I'm a person who has diabetics. So, Lamai, for example, I'll go to Selinco Insurance Company. I'll go to Selinco Insurance Company, and what I do is, uh, I obtain a life insurance company, and Lamai, I obtain the coverage only for what damages that happens to my life due to diabetes. Due to what Lamai? Diabetes. So once again, it's very simple. It's very simple. It's very simple. What do? I just what? I just go to Selinco Insurance Company and I just obtain insurance coverage. But the problem is that insurance coverage is obtained to cover damages happen to me through diabetes. Let's assume, Lama, yeah, I have diabetes. That's a different story. Let's assume, kids, after obtaining the coverage, after on 2 months, Lama, I'm die. Okay, no, I just died. Yeah, I just died. So assume, Lama, I just died and. Now you know Lama, there'll be what there'll be an FIR. There are a lot of things. I mean, FIR, sorry. eh, Those reports will be taken, and yeah, various lot of things wi- will be what done, Lama. And when I receive that what report, Marana Pariksha Vaarta वगैरह, when I receive that Lama, not me, like the person who is in charge of me, and Lama, they'll specifically mention the cause of death. And in the cause of death, what they have mentioned is heart attack. So, which means in such a scenario, Lamai, the proximate cause is not covered by the insurance policy, which means insurance company can what avoid you paying the compensation. So what is proximate cause? Proximate cause means out of the several reasons that led for the damage, the immediate reason, the real reason, the most possible reason that led for your damage, what do you call it, kids? You call it proximate cause. And remember, to obtain compensation, the proximate cause should be covered by the insurance policy. Are we clear, kids? Are we clear? So to what? Obtain the coverage. To obtain the whatever the coverage it might be. Sorry, maybe compensation. Once again, to obtain the necessary compensation, always the proximate cost should be covered by the insurance policy. In my scenario, am I like the dependencies, the people who are dependent from me, no, they cannot what obtain the compensation. What is the reason? Because I obtain a insurance coverage for damages which happens to me through diabetics. But now, what is the proximate reason for my death? It's heart attack. So I won't what get the compensation because not me. The dependence of me will not get the compensation because what the proximate cause is not covered by the what am I? Proximate cause is not covered by the insu- uh, insurance policy. Next one, something very tempting, indemnity. So as I was mentioning earlier, Lamai, there are six. Yeah, I told you all perfectly, right? Cannot remember. Huh? When it comes to insurance, Lamai, when it comes to insurance, it has policies as well as what? It has policies as well as principles. So now my policies, there are only two policies. We have general insurance policy and we have life insurance policy. What is general insurance policy? General insurance policy is also known as my property insurance. But I don't like it, but okay, can still call it property insurance. So you call it short-term insurance. On the other hand, you have assurance or life insurance. So you can call it long-term insurance. I mean, so if you ask me, so what are policies? They are just insurance coverages. On the other hand, we have principles. We have six principles. And what is an insurance principle? Principles of various rules and regulations that is available in the insurance law. And we have six. Namely, I told you all insurable interest. It is the legal right you have to insure something. Then utmost good faith, disclosing all the relevant information appropriately. Then I told you about the proximate cause. And remember, all what I mean, like all the life insurance policies, whether it's sorry, all the insurance policies, whether it's general life or not, that three will be affected. But the most important point I told it earlier. We apart from those what insurance policies or insurance principles, we have indemnity, subrogation, and contribution. These three policies, these three principles, it's only affecting what? It's only affecting general insurance policies, Lama. They are not affecting life insurance policies. I told you the reason as well. Let's what get to know it further. So, what is indemnity? So, Lama, indemnity subrogation contribution. Always remember, it's not affecting what life insurance policies. It's only affecting general insurance policy. General, like Lama, all six principles in affect. Palini do not affect it. It do not affect it. For life insurance, only the first three. So, Lama, what is indemnity? Lama, indemnity. When an insured property is damaged, Lamai, the compensation will be paid only to reinstate the damaged property. For example, I just insured my motor vehicle for 5 lakhs in Jana Shakti, and my vehicle is met with an accident and the damage is, let's assume, 2 lakhs. So, Lamai, compensation will be only received for 2 lakhs. I will not receive what a single penny more than 2 lakhs because the fundamental concept of indemnity is what Lamai. Through insurance, no one should earn profits. Through insurance, no one should earn profits. And now I told an interesting point earlier, right? I told you that in life insurance policies, yes, Lama, indemnity is not applicable. And earlier I told the reason as well. So, Lama, when it comes to life insurance policies, in a life insurance policy, Lama, in a life insurance policy, I mean, you simply obtain a coverage for like I mean, to cover any losses to your dependencies if something happened to your life. That is life insurance. If example, within the policy period, if you die, that predefined amount should be given to the what? Dependents. For example, once again, let's take me. I obtain a life insurance policy, and I am agreeing to what? Pay the premium, okay. And Lama, let's assume I died within the policy period. I obtained the policy period for 5 years, and within what 2 3 years I die. So then Lama, they should definitely provide the agreed compensation to my dependencies. Yes, I think like the value of the losses is what not considered because when it comes to what death, Lama, I mean, when it comes to death, whatever you do. If you die, you die. If you die, you die. මම මැරුණා නම් මම මැරුණ එච්චරයි. මගේ වලගාවට කොච්චර සල්ලි ගෙනලා දැම්මත් මම නැගිටින්නේ නෑනේ. How much of money what? How much of money Janashakti will come and pour to my what grave? I will not what? I'm a negative nan. So which means indemnity ke kiyanne, the compensation should be given to reinstate the damaged property. So lamai, okay, mama hondere hidiya, all of a sudden I died. So what was the damage? It's death. So how much of compensation you give lamai? I mean, that cannot be replaced, right? So, which means indemnity is not applicable because indemnity is telling compensation will be given to reinstate the damaged property, which means that if a property is damaged, you should give the necessary amount to what? Bring it back to the original state. Original means to the state where it was before the damages happened. So, I am okay, I'm on the rain now. Okay, I'm all good. So, all of a sudden, I die. All of a sudden, I die. Huh? So, kids, no matter how much of compensation, which means no matter how much of money they poured in my grave, Lama, I won't what? I won't raise back. No, no, it. This is not Harry Potter. Those things will not happen here. So, which means the indemnity is not applicable. Huh? And the value of life is that's why the value of life is immeasurable. Because kids, no matter how much of money you have, if you I mean, death is certain. Death is certain for everyone. Death is certain for everyone. It's certain for everyone. Simple as that. I mean, you can't restrict. That makes the value of life immeasurable. බලන්න නිකං කටවචනේ මං කියනට value of life is immeasurable. What makes value of life immeasurable? Because after you die, the story ends there. In this world, the story ends there. So you, no matter what you have done or what is done afterwards, you won't want to trace back. Next one. Then Lamai, yeah, Castellian and we have Preston. There's a case, yes. Then Lamai 1990, 19, sorry, it's 1883 key and Lamai, those are common, mostly common law cases, as I was mentioned earlier. When it comes to legal systems of the country, you can mainly categorize it as Roman Dutch legal system and yeah, the what English common law system Lamai, and usually me English common law Lamai, it's not it's not fully written, but Lamai, like the Roman Dutch ulama, it's written. When it comes to me, like English common law, it's mostly built with kids. If I go further, it will be too much for y'all. But English common law is mostly built with lama judgments given by the what? Judgments given by judges lama. Mostly it's that lama. You mostly case laws are only used to what? Provide judgments. I mean, ara potak kila what? Like there is no what? There is no fixed framework. But in Roman Dutch law lama. Roman Dutch law, like we have what? Julius, like we have people like Julius, we have Augustus. Yeah, like they have what? I mean, they have separate books which specifically mention what you should do for this. Like specifically, Lamai, they have mentioned the rules. There are huge they're huge books. Yeah, like if you, I mean, I can talk about the evolution of Roman Dutch law here as well, but it will be what too much for you. And but when it comes to English common law, my English common law, rahim like there is no book. Or me katama ya me katama ye katila. There is no book la my English common law, but fully functioning based on what judgments of uh, what judgments of our judges, Lamai. And you call it jurisprudence. What do you call it, Lamai? Jurisprudence. Yeah, like based on jurisprudence only, Lamai. Uh, like English common law is built, which means Latin like previous case if the facts are a bit same, case like judgment is given for the present case. Yes, that's in English law. Okay. When it comes to Roman Dutch, no, there are what's I can remember there are puttina, Renaissance college, like you have the huge books and everything is mentioned there. Like make it a make, but it's impractical. My labor rules are not applicable today. What gonna come to law faculty? Come to law faculty. Come to law faculty, you'll teach. You'll learn all those things. Ah, huh. Okay, interesting, right? Yeah, that's why I say law is really interesting. Law is really interesting. Okay, තමයි ඔය රෝමන් ඩච් වලත් තියන ගැලපෙන්නේ දැන් වලට කොහොමද කරන්නේ? I'm going to. So anyway, ළමයි, let's see what this case කියලා. බලමු මේ case එක මොකක්ද කියලා. Let's see what's this case කියලා. And with that, we are done, right? I'm done with it. Is this case? Yeah. So what happens here, kids? A house was insured against fire. Then the insured sold the house before what? Completion of the sale. The house was damaged by fire. The insurer paid the damage, and later the purchaser paid the full price for the house and the what? And the how? Okay. And when the house And when the insurer learnt of this, okay, they claim of return for the payment of their policy. Court decided that insurer's claim should succeed because otherwise insurer would have made a But just analyze the fact of this case, Ramai. Just analyze the fact of this case. Okay, there was a particular house, Ramai. It is insured against fire. And the insured what? The insured means the person who obtained the coverage. Ne? That person has sold the house before what? Completion of the sale. Hmm? Only right. Then Lamai, the house was damaged by fire afterwards. And Lama insurer paid the what? Damage for the damage and later yeah, Himai. It's like okay. I have insured my house, Mamma ke house ke insure kala diya. And Lamai and the most important thing is Lamai that yeah, that now I'm selling that house before the sale, and okay, fine. And later plus the house is being damaged. Now Lamai, the key point is I have sold the house. Ne? I have sold the house. We could live it. So which means I have take the full amount from the purchase as well. අනිත් පැත්තෙන් ඉන්ෂුරත් මොනවද කරන්නේ? ඉන්ෂුරත් ළමයි මේ compensation taker. So which means after insurance company get you to know that they are reclaiming the compensation they paid, and the court is saying that this particular person should what repay it as well. Think simple name in mama like okay, mama mage ගෙදර insure like mama මගේ ගෙදර insure කරලා දෙනවා. And I'm selling it to what? Mistakes. මම mistakes ගෙදර විකුණනවා. And mistakes ටිකකට පස්සේ ගෙදර 5 කින් damage වෙනවා. එතකොට මම දැන් sale එක complete උත් නැහැ. Sale එක complete නැහැ කියන්නේ and ownership එක transfer කරලා නැහැ. The ownership is not transfer. බලන්න කොච්චර ලස්සනද කියලා just imagine ළමයි these things are really nice. ඒ පොඩි දේවල් අල්ලගන්න like those what small things you should what like you should talk about those small things. So which means okay, I have injured my house and I have what? I have sold my house to mistakes. But the sale is not complete, which means the ownership have not been what answered. Maybe the deeds have not yet written. Maybe it's not yet transferred. And soon after after mistakes has given me the money, the full money for the house, or I mean like mistakes is giving me the money like, before the fire is happening. So which means he's giving the full amount. And now the what? House is damaged through fire. And now what I do is I inform that to what insurance company, and they will estimate the damage and they'll also give me the compensation. But the problem is, do I have the legal ownership of the house? No, the house is actually what sold to mistakes. As per my compensation, that should be not received to me. That should be received to mistakes because now the worth of the house is reduced, and that affects mistakes, not me. And for me, it's a profit. I got the what entire amount for the house as well before the damage, and now I get what compensation for the damage for a house which is not now owned by me. මට අයිති නැති මම ගෙදර විකුණලා ලක්ෂ 50ක් ගත්තා. and ඊට පස්සේ ගෙදර fire එකෙන් damage වෙලා ලක්ෂ 5ක් කියන්නකො. ආයෙ ලක්ෂ 5ක් මට හම්බෙනවා කොහෙන්ද නම්? Insurance company. It's so interesting. It's so interesting. So interesting. My profit is, I mean, now the worth of the house is 45 lakhs. ගෙදර වටිනාකම ලක්ෂ 40. And the most important thing is it's not owned by me. Huh? It's not owned by me. So now who should bear the loss? Mr. X. Not Atala, ne? So now what has happened is anyway, මෙතන මෙහෙමයි, they are not talking about talking with like in the real case it's there. So the real thing is mistakes will what now inform the insurance company. කියලා මෙහෙමයි මේක මෙහෙමයි. මෙයා මම මෙයාට ලක්ෂ 50 දුන්නා. I gave this bugger 50 lakhs and what he the house was sold, but the problem was he did not what, transfer the deeds yet. Uh, But now, since the deeds are not transferred, you are giving the compensation to that person. But the house is now mine. You should give compensation to me. Then, when insurance company gets know that, tell me them a case like you me, give me the what? Refund me. Please, refund me. Sellan just refund me. What kocha lassan because the concept is through insurance, no one should earn what profits. Yeah, through insurance, no one should earn profits. Interesting, Sulama. Let's go to the sub characteristics of what? Let's go to the sub characteristics of indemnity, which is obviously subrogation and contribution. Interesting. From Lamai, when it comes to insurance, yeah, I can cook it like nothing. The reason for that is Lamai, I have lot of experience with insurance companies. Yes. Like Pudduma, I have superb experience with what? Insurance company because I work a lot with them. Yeah, I work a lot with them. And I won't. I'll avoid telling the reason why. එහෙම තියෙන්න කියලා. But ඒක මෙතනට ඕනේ නැහැ. ඒක වෙනම මගේ personal හේතුවක් ඉඳලා තමයි. But ඒ දේ වෙනවා. ඉතින් ඒ දේ වෙද්දී ඉතින් I have to what contact insurance companies a lot. Okay, fine. Okay, fine. And me, මම like I do nice things with them as well. But ඒක මෙතන කියන්න බෑ. It will not. It will hurt. It will affect my integrity. Alright, next one. Let's go to subrogation. Subrogation is a nice concept la mai. Metan subrogation is still la mai. Example, let's assume, okay, let's assume I'm just traveling in the motor vehicle. I'm motor vehicle like travel karna. And remember la mai, when it comes to motor, yeah, according to what? According to fundamental rules of the country la mai, if a particular vehicle is inserted in the road la mai, if it's traveling on the road, at least the minimum third party insurance should be obtained. Done on at least the what kids, at least the minimum, yeah, minimum third party insurance should be available. When it comes to motor traffic insurance, we have what? Three types of motor traffic insurance. We have the full insurance, we have the what, third party fire and theft, we have the what? Minimum third party. So simply, if you're traveling or if you're laying down your motor vehicle to the road, minimum you should have the third party insurance. Minimum third party. So let's assume like, in my case, I have the full insurance, for example. I have the full insurance and I'm traveling in the motor vehicle. And let's assume like, I'm hitting what? A person called Mr. Y. Mangi Mr. Y happen. I'm just what traveling properly. Mr. Y is what coming and damaging my motor vehicle. Or he's what? He's meeting an accident with me and the mistake is with him. And the mistake is with him. So Lama, I have full insurance. I have full insurance. So what can I do is I can just call the insurance company. I can just what? Okay, I can just take some photos and WhatsApp them, and I should what, fill the entry form, and I should get a police report, and all those things are done. Then I can get the compensation. Compensation got the and Mr. Y, mom putting in like I'll just start to scold him and I'll do something and mistakes. I'll tell, okay, like let's say my name. Mr. Y has no license. Mr. Y has no license. So what I'll do is me my like I'll go to police mom police. Kelima la my license na tu la my happo again. Kelima you'll be what remand only. Hmm? Remand only. Direct road remand only. Kelima la my remand. Apa dila you'll be what? You'll be bailed out. What? Salli velta tama. Say no sella. It's the most important thing is now mistakes will be definitely afraid lama. Then he'll what try to give me a particular amount. May my son take this 1 lakh, 2 lakh. What api godin beraga. I godin beraga. Now what has happened? Now I have received what? 1 lakh or 2 lakh from that mistakes, Mr. Y as well. And insurance company is also what paying me the damage. Ito lang, ito lang, profit take maintain. What is indemnity concept telling? Indemnity concept is telling no one should earn profits through what? Insurance. Hmm? But now, let's assume my damage of the car was 2 lakhs. Now, insurance companies give me 2 lakhs. Okay, okay, when I should what? Hand over the my motor vehicle to the what? Nearest to whatever the garage, and quotation should be taken, and that quotation should be sent to the what? Insurance company. Insurance company will approve it, and the fund will be directly transferred to the garage. They won't give me money to my hand. No, no, those things will not happen. Those things will not happen. So Lama, let's assume, yeah, the insurance company is what paying the compensation, and on the other hand, Mr. Y is what giving me what another 2 lakhs. So the damage is 2 lakhs, but I earn what 4 lakhs. No, no, you're what avoiding indemnity principle, and to avoid that, Lama, we have a nice concept called segregation. But once the compensation is paid, the insured should transfer all the economic benefits he may receive from the insured object to insure, which means after insurance company paying me the compensation, like if any external party give me any advantage, or give me like if there is any economic benefit that is what receivable to me from an external party, that should be directly transferred to insurance company. Simple as that, ladies and gentlemen. What is subrogation? Subrogation is telling after compensation is paid by the insurance company to me or the insured, yes, if any other external economic advantages are receivable to the insured from other parties, all those what rights are transferred to insurance company. I mean, obviously, we know it's not applicable for life insurance because the value of life is immeasurable. Insurance company ki yadunna. How much insurance company give? I cannot be what? I'm a merro, setta boji. No one can what? Like it run the demo. So I think Anitya then advantages is we can take it. It means my dependency. Okay. Contribution. What is contribution? Contribution was what? You got superior. Lamai contribution principle is there, and it's used in scenarios where a double insurance policy is applicable. What is applicable? Double insurance policy is applicable. So you might be all of a sudden you might be wondering, sir, what is double insurance? Lamai double insurance kya hai? It's done by us, which means the insured or insuree, which means we go to multiple insurance companies and insure ourselves in what multiple insurance companies. Example, let's take I just what take a motor vehicle and I just insure it in what Jana Shakti, AIA, and Selimco. So that is a double insurance. Like here the insured or insuree by himself visit to what multiple insurance company and what obtain multiple coverages. Let's assume I'm insuring my motor vehicle in three insurance companies, Jana Shakti, Selinko, and AIA. Each insurance company for 1 lakh. Each insurance company for how much? And now my motor vehicle is accident and the damage is 90,000. Now don't think all what three insurance companies will give me 90,000, 90,000, 90,000. Then how much of compensation I'll get? 2,70,000. But the damage is 90,000. So the profit is 180,000. No, no, those shit is not happening here. No, ain't. Once again, if such thing happens, it's violating indemnity concept because you can't earn profits through insurance. Obits very clear. In such a scenario, the compensation will be provided proportionately. So Lama, in all the insurance companies, I just insured it for 1 lakh, 1 lakh, 1 lakh, right? So which means what does they do? They just take the compensation, which is 90,000, they just divide it among them equally. So you divide it into three portions because I insure in three companies and each company will provide me 30,000. So 30, 30, 30. Yes, I get how much? 90,000. That is contribution. Are we clear? Yes, my dear students, are we clear? I think it's almost what? almost everything is clear for you, right? What is contribution? Contribution is nothing but what? Contribution is nothing, but it's applicable in scenarios where double insurance come to what? Play their role. How does double insurance happens? Insured insure the motor vehicle in multiple insurance companies, but AMI when that property is damaged, you won't get compensation from all insurance companies. What happens is, I mean, you don't get the full amount of compensation from all the insurance companies. What happens is all the insurance companies will proportionately contribute to compensation. Be clear. Yes, students, I'm asking once again, we clear? Yes, right? Everything clear? Everything done? I think, yes, the insurance is not perfectly done, right? Yeah, the insurance thing was perfectly done. Yeah. So again, yeah, I started from what? From the very beginning, and I just want to explain with cases. Hmm. I just explained everything for you. So hope but everything is clear. Insurance, nothing, kids. Insurance, nothing. You, what is insurance? What is insurance? It's enough. It's almost enough. It's enough. I think. So that's it for today. Yeah, that's it for today. I'll just hand over the meeting to the other lecturer. Hmm. She might end the session. Yes, she started the session perfectly, and let her attend the session perfectly. A quick recap, finally, kids. A quick recap. What is insurance? What is insurance? What is insurance? Shall I explain you in very simple terms? Shall I explain you in very simple terms? When it comes to insurance, yes, kids, insurance means it's an agreement between two parties, which means that it is an agreement between us and the insurance companies. Us means we call it insured or insuree, or the first party with what? Insurer or insurance company, or you call it second party, whereby we agrees to what? We agrees to pay the premium. You know what's premium, right? Premium is the amount of money which we get to obtain the insurance policy. An insurance company agrees to pay the compensation. What is compensation? It is the amount once again given by the insurance company to us to reinstate our damaged property. If it's obviously damaged due to the insured risk, fire insurance fire insurance is damaged due to tsunami. I can't obtain compensation for that. That's a different story. So Lamai, then there was an interesting point where they were explaining fire, life, marine. You know what's fire insurance, right? Fire insurance Lamai, when it comes to fire insurance, it's an interesting thing. When it comes to fire insurance, it's an interesting thing. If fire it's not just what damages which happens through what just fire. You can email to be honest, this fire insurance policy, you can expand it. It can be used to cover losses what? Through explosions, through earthquakes, through tsunamis. But you should subscribe for it. Just if you take fire insurance, they'll only what? They'll only cover losses through fire, but you should specifically take those things. You can what? Cover losses which happens through explosions, accidents, strikes, crashes, tsunamis, then earthquakes, plenty. But the more you take, the more the premium will be. Remember that as well. Then Lama, we have life insurance, which is generally known as assurance. It is the what? It is the policy you get to what? It is the policy you obtain to cover losses that might happen to your life. Obviously, it's death. Then marine, what is marine insurance? It is the insurance policy which is available to cover losses that happens to vehicles when they are traveling through water, which can be categorized as hull insurance and matlamai cargo insurance, which can be categorized as hull and cargo. What is hull? Hull means it covers losses for the ship and the cargo. Cargo means only the goods which is traveling, not the ship. hull එකත් ළමයි ඇතුලේ තියෙනවා. We have what? A comprehensive policy, total risk policy. Plenty. total loss policy. Then what are the sub parties of when it comes to cargo cargo ke we have a floating policy, value policy, all those things. Yeah. Are. So yeah. And when it comes to those things, they are what is applicable for them lama English common law. English law is well known as common law man kila don lama. It's originated in Great Britain, and lama mostly this law is not documented. The what uh, when it comes to English, the countries which implement English common law, Great Britain wage lama, they provide judgment based on case laws or jurisprudence lama. When it comes to Roman Dutch law lama, Roman Dutch law means like the law is documented. It's documented and it's used in countries like uh, Italy again, then Lamai. Then what about Sri Lanka? Well, Sri Lanka is the country which has a mixed legal system, which consists of English common law as well, English common law principles as well as Roman Dutch law principles. Yes. South Africa, Sri Lanka, we are countries. Our constitution is built based on both legal systems, which means that it contains principles of English common law as well as it consists of what Roman Dutch law. Because, Lama, to be honest, in these what each and every type of legal system, they have their own advantages and disadvantages. I think I should not put in separate session. I can teach. It's not a difficult thing. I mean, for example, Roman Dutch law වලත් වගේ negativities වගේ තමයි the impracticalness of laws ළමයි. The laws which were introduced in backdate, it's not applicable today. And ළමයි, the problem with English common law is ළමයි, it's not documented, so it's really difficult. It's very difficult to provide judgments because judgments are based on previous cases, and we can't like. And the most important thing is ළමයි, in English common law we are more relying on uh, the decision of judges rather than a book note. Now you might be wondering, sir, ඉතින් ඒකේ මොකක්ද තියෙන අවුල? ළමයි අවුල කියන්නේ we don't know like judges are not perfect name. No one is perfect to be honest. We like judges can. I mean, I'm not criticizing a judge, but always we can't say a judge is giving a judgment based on bona fide intention. There might be malafide intention as well. ළමයි. I mean, come on, we all are humans, ne? Come on. But Roman Dutch එකේ ප්‍රශ්නේ තියෙන්නේ lack of judges involvement. අර පොත්පත් වලට අනුව like decisions are given, their reality set නෑ. So that's why Sri Lanka is not having a mix of both. So Lamai, I think that part is very clear for you. Then Lamai, we were talking about elements of insurance contract. Oh, I told it nice. You could Lamai. What are the conditions that should be available to validate an insurance agreement? Hmm? First of all, I told you I think the obligations can what is an obligation? It is the what? It is the responsibility. We have to pay something to some person. We have two types of obligations. One is legal obligation, next one is constructive obligation. Well, legal obligations are official obligations which cannot be changed from time to time, which arose from contracts, laws, and statutes and through court orders. Well, constructive obligations are unofficial obligations which change from time to time. They are derived from entities' actions and kids. They arose from past practices. They arose from current statements, and they arose from published policies. Yes. Ask anything about those things that I'll clarify them. Not those things are not big things for me. So kids, first of all, when it comes to make a mom මෙතනින් මුල් පාට එක once again පැටලෙන ඉඳන් මම මෙතනින් මේක කියලා නතර කරන්න. Because once again, no point of what teaching. I think I did pay. Everything is done perfectly well. So I have to attend another class. That's why. So kids, the most important thing of insurance is Lamai. We muna baila what insurance thing happens in three stages. Kauru mono kigot. Whoever tell whatever the shit insurance happen in three stages. First one is insurance proposal. Second one is insurance agreement. Third one is insurance certificate. Yes. First of all, what happens? Insurance proposal, which means we who need to obtain the insurance coverage should go to the insurance company and what request the insurance coverage or the policy. You're requesting the insurance coverage. That is proposal. Then what do? They meet ඒක තමයි මෙතන කියන්නේ. They are telling step by step. That's what they are telling here. First of all, what is it, lamai? Then like, okay. Once again, change that proposal of what is proposal. Insurance proposal means offer means like we who are the insured or insuree requesting the insurance company to provide us what coverage or a policy. Simple. එතකොට ළමයි වැඩේ කියන්නේ මේ to be honest, as we all know, අපි හැමෝම දන්නවා ළමයි. Insurance company will not provide you what I mean, yeah, නිකන් like all of a sudden they won't what for free they won't provide you a policy, right? What should you do? What should you do? You should pay a premium, so which means it's an obligation. So you should what intention to create a legal obligation. You should be willing to create a legal obligation. You call it idea of legal obligation. I mean, you should what willing to pay the premium. Proposal දාන්නත් කලින් ඉතින් proposal දාන්නත් කලින් you'd be willing to pay the bloody what premium. You should be willing to pay the premium. First, you should be willing to pay the premiums, and paying the premium is an obligation because the obligation means it's the what responsible to pay something to some person. Hope it's perfectly clear. Then, after accepting the what obligation, then you make the proposal. Then insurance company will what will evaluate all the necessary things which you have mentioned in the offer or the proposal, and if it's acceptable, if you have maintained the utmost good faith, and if there is no material misrepresentations, obviously kids they'll accept it. And next one is legal validity. Then they'll check what is it legitimate, or is it legally accepted, or is it what applying with law in order to what provide you the coverage or the policy. Then my next one is competent parties. My other party also should what be willing to accept the obligation. Who is the other party here? Insurance company. What is the obligation for them? Paying the compensation. So yeah, they should what? Premium pay that will not be insurance. We should agree to pay the premium. They should agree to what? Pay the compensation. If both parties will not what accept their responsibilities or obligations, there'll be no agreement. So you know what's insurance agreement? We what? Second thing, we agrees to pay the premium, they agrees to pay the compensation. Yes, that's that. Then finally, what was the third stage I told you? What was it? Insurance. What is it? Insurance certificate. So what is the insurance certificate? It is the final document which is issued by insurance company to the insured after providing insurance coverage, because that is very important. Insurance certificate is very important in your when obtaining insurance compensation. කවර මොට් එකක් තියෙන උතනදී මට කියන්න හිතනවා but keep it as it is. So then our consideration can the amount, the amount that should be paid as the premium, and that depends on the risk and various other factors. Hope everything is pretty much clear. So I hope everything is pretty much clear. Then I think that's all for today. How was today's session? I think it just perfectly went well. And I'll hand over this session to the other lecturer. Yes, madam, you may, but if you want, you can tell something to students. And yeah, you can wind up the session. Yeah, you wind up. If you need to say something, students, you tell it.
So then like we have completed, no? Even for the low students, for the second stage students also we have did a part. And once if you're having any doubt, you can upload in the group. And thank you.